Yes, please. Yes.
Lord's kind leave to mention a matter, my lords.
1 second, sorry. Yes.
Lords, I was praying for my lord's kind leave, my lord, to move, file and move an urgent order 41 rule 11 application, my lord, at 2 p.m. My lord, subject to my
What is urgency?
lord, urgency, my lord, an order has been passed on 18th and matter is fixed on 20th, my lord.
20th is today.
Sorry, 22nd, sorry, I stand correctly. 22nd, that is day after, my lord.
File it, hand over the slip.
My lord.
File it in the department and hand over the slip.
But may it appear tomorrow, my lord. I'll just
Very well. File it immediately and hand over the slip. Only hand over করলে স্লিপটা এটা আনিয়ে নিয়ে কালকে অর্ডার ফর টেন দেবে। Yes.
My lord, applications.
Yes, sir.
My lord, hearing.
Hearing no. Yes. Application please hand over.
Application for modification, my last date of payment has already expired.
Applications and order 41s please hand over the slips without mentioning.
Paying for listing of this application for modification of lordship.
Application and order 41 please hand over without mentioning.
দুটো separate applications.
Hearing not right now.
For inclusion.
আচ্ছা এখন কি
There's extreme urgency because your lordship had quashed all the proceedings relying on sections 95 and 96 of the Insolvency and Bankruptcy Code. But
Mr.
despite
Gupta,
the sale notice,
I cannot take it up before 31st because 24th I may not be there.
but could it be any day before? Because the bank has issued a sale notice.
No, Mr. Gupta, no, we cannot break their norms. We are sitting division bench in division bench previous to that. We cannot do that.
Your 24th, your lordship is not.
No, I may not be there. So no.
Only urgency is that my sale notice has been issued despite everything.
That's what Mr.
quashed by
Gupta
your lordship.
tell them that the court is blame it on the court.
We have served. Yes, we have served.
Blame it on the court. Say that the court is not sitting. Yes.
On the 31st, if it could get some precedence, my lord. I'll hand up the slip, my lord.
31st, yes, but then mention on 27th. Then.
I shall.
Yes.
Grateful.
One and two are connected appeals, blood. 1 and 2, blood. On 8 January, your lordship passed the order directing the department to submit a report whether appeal is otherwise ready. LCR has
Let
come.
us just check up, please.
Matter was mentioned for direction to file paper.
You are appearing for the appellant, Mr. Chakut.
Appellant in one matter, first matter, and respondent in that matter.
The report is first part of the report says that the notice could not be served due to non-availability of the advocate. So you please ensure that at least in your appeal you take the notice from the department.
Well, I am for the
They have appeared. blood.
Then notice of appeal after the records for preparation of paper books. Notice of arrival of the trial court records.
Notice of arrival of paper book has LCR has not.
The LCR has
Well,
come.
It has come.
Is- well, notice of arrival record has not been served.
Mr. Brokit, you could not be found when they sought to serve you. Please send your clerk or whoever, ensure that the notice is taken from the office. Notice,
No,
the records
notice-
are already there. Just do
Notice
that.
has not been served, yes.
Mr. Rokit, you could not be found when the notice was sought to be served. So please ensure that it is taken from the department.
As you lordship.
It transpires from the report of the Assistant Registrar 2, First Appeal Section, dated January 18, 2025, that the trial court records have already arrived, but the notice could not be served due to non-availability of the learned advocate for the appellant. Push up next para. The learned advocates for the parties are requested to ensure that they receive the notice of arrival of the trial court records from the office and carry out the necessary directions regarding filing of paper books.
But within a positive direction, maybe pass certain time limit. I shall file paperwork. Otherwise, it will be again I have to mention.
No, you are for the appellant.
I'm appellant for the.
No, there was no direction for filing a time limit for filing a paper books. There was a direction.
8 weeks after service of notice.
8 weeks after service.
way back in
Yes.
That remains 8 weeks after service. That
But
order
that
is.
was served upon the Mr.
Anyway,
Rohit's
Mr.
client.
Chakraborty,
Because
there is a.
I shall file paper book. My client
Do
will
it,
file,
do it.
otherwise my client will suffer, my lord.
Do it, do it.
Aged person, my lord. After within 4 weeks after
No, 8
serving of-
weeks was the direction already there. So do
No,
it.
not there, my lord. It is way back in 2019 upon Mr. Rohit's client.
Way
Mr.
back in-
Rohit did not take.
Oh, you want to prepare the paperwork for both the matters?
All the combined paper.
You are the respondent in
Respondent in second matter.
second matter means FA number.
FA 120 of 2019.
Very well, we will direct them, Mr. Chakraborty, Mr. Rohit.
Yes.
Mr. Chakraborty, the learned advocate appearing for the respondent in FA number 120 of 2019 submits that due to the urgency involved, the said respondent is prepared to file the paper books in connection with both the appeals within 4 weeks from date. Full stop. Next para. Accordingly, the respondent in FA 120 of 2019 is directed to file paper books, informal paper books within 4 weeks from date. Full stop. Liberty to the parties to mention for inclusion in the list as and when the appeal is made ready for hearing. Thank you, Mr. Chakraborty.
Great.
Next.
Thank you.
Yes,
Time for the
written notes.
respondent
Written
on
notes.
the written notes of argument.
You have already filed your written notes, right? ঠিক আছে, দিতে হবে না, নিয়ে নিন। ওনার সরি ওনার কপিটা। The written notes filed by the respondent today be kept on record. Full stop. Hearing is concluded and the matter is reserved for judgment. Okay. Call on the next. Was it appearing as 6 কল করে একটু ওয়েট করতে হবে। আর একটু বাইরে কেউ একটা গিয়ে বলে দিন যে আবার সবাইকে ডাকছে। You please just convey to the other advocates that we are taking up matters now. লাইভ স্ট্রিমিংটা আগে অন করে দিন। হ্যাঁ, এই তো হয়ে গেল। Yes. 6টা কল করে একটু টাইম দিন, আমরা তো বাইরে বার করি। Item 6.
6 মানে I am
Who is for the other side? We'll wait for a
Mr.
minute
Tolman,
because we
মানে
asked the advocates to go out, so we'll wait for some time.
yes ma'am.
You are appearing for that. Very well.
মানে
6, what is the matter?
মানে Mr. Piyush Choudhury is appearing in
Yes,
this
sir.
Mr. Piyush
He
Choudhury
was here. We asked him to go out because of the in-camera thing.
মানে matter is fallen just
Sir,
by
it's a simple, my lord, it's substitution application on the last day I submitted.
Substitution within time.
No, substitution along with section 5, but I submitted before your lordship that I could able to secure the wakalatnama so far as regards 1A to 1C is concerned.
What is the delay?
Delay, my lord, the separate section.
Some live streaming is going on in my court. Sama.
মানে
কি কোথায় চলছে? কারো ফোনে? কার ফোনে?
মানে my mobile was on my lord. That's why I'm paying for
It was your phone.
I'm paying for applause my lord.
So the live streaming of this court was going on there.
my lord.
Yes. What is the
30 days
delay?
short
What is the delay?
But the delay 930 days.
What is your explanation? You have put it entirely on Mr. Chaturvedi. You are the advocate. You are not ready in your matter.
My lord, kindly page 5, paragraph 8, my lord. But the instant appeal being FMA number 1055 of 2019 came up before the Lordship of Honorable Justice Modores.
You learned from them.
Yes,
From
my
this.
lord.
They reside.
They have filed the
The
substitution.
respondent number 1 resides elsewhere, not in your premises.
Yes, my lord.
Yes.
So, occasion, my lord, your lordship's pleasure was that, my lord, since ultimately everything boils down to in respect
Well,
of a money.
I am-
So, my lord, your lordship, my lord, opined that in respect to 1A to 1C, since I could able to, my lord, secure the wakalatnama, he has to serve to
File this
Jyoti Singh.
affidavit of service, my lord. I already served the Jyoti Singh, my lord.
Good service.
Receipt.
Receive. So we'll allow this.
Yes, my lord, your lordships allow that, my lord. And my lord,
Lordship kindly
my
fix the
client
matter.
sent the wakalatnama on 16th by post from Allahabad. My lord, I till date has not received. My lord, your lordship gives me, my lord, 10 days time. My lord, by that time, my lord, I will
For whom?
for 1A to 1C.
Very well.
Yes.
Uh,
Lordship kindly fix the matter. Any
Learned,
for the-
now, Mr. Mukherjee, learned counsel, having instruction to appear for the respondents through his advocate on record, submits that some time may be given to file wakalatnama for the proposed substituted respondents. Push-up, you can file it by
By, my lord, 10 days.
push-up. Accordingly, 10 days time is granted to the proposed substituted respondents to have their wakalatnama filed in court, filed in the department. Push-up, next para. Can 3 of 2024 is an application for condonation of delay in filing an application for substitution upon setting aside abatement. Push-up, next para. We find from the averments made therein that the appellant for the first time came to know of the demise of the original respondent number 1 from the submission in that regard made by learned advocate appearing for the respondents before court on July 18, 2024. Push-up. Hence, we find that there is sufficient reasonable explanation for the delay in filing the present application, in filing the application for substitution after setting aside abatement. Push-up. Accordingly, can 3 of 2024 is allowed on contest, thereby condoning the delay in filing can 2 of 2024. Push-up, can 2 of 20, since the reasoning given by the appellant for the delay overlaps with the reason for the delay in filing the substitution application beyond 90 days and before the expiry of further 60 days as well, can 2 of 2024 is also allowed, thereby directing the heirs and legal representatives of the deceased respondent number 1, Srimati Gauri Singh, as in place and state of the said deceased as respondents in the appeal, comma, upon setting aside the abatement. Push up next para. The necessary consequential corrections shall be carried out in the memorandum of the appeal by the department of this court within a fortnight from date. Push up the file be sent down to the department for such purpose. What were you, Mr. Chaudhary, you were asking for fixation of what? I mean,
But,
what is pending? Any other application is pending?
my order 9 rule 13 has been rejected.
Or the main appeal you are saying? So we can grant you pass a direction for you to prepare informal paper books, and we can
Already prepared.
paper books are prepared. Then we will direct the appeal to British. Very well.
Only within 15 days time, your lordship has already granted for the department to correct.
No, we'll
the
keep it after that.
Yes,
Definitely.
not only that, but if my learned senior friend can put the requisite for service of appeal upon the 1D, because 1D I could not able to not appear. I must be candid
Yes.
before your lordship.
Yes.
So that not appeal can be expedited hearing. I am appearing for the rest of the respondent.
Right. The appellant shall put in the requisites for service of notice of appeal on the substituted respondent number 1 small d within a week from date. Full stop. The appellant shall also prepare and file. Acha, you have already filed. Full stop. Next para. It is submitted by learned senior counsel for the appellant that the appeal is otherwise ready for hearing and the paper books have been filed. Pushed up. Accordingly, the office is directed to furnish a report as and when the notice of appeal is served on this substituted respondent number 1D. Pushed up. Liberty to the parties to mention the appeal for inclusion in the list immediately thereafter. Mr. Chaturvedi, please just ask your clerk to keep a track. Whenever that is complete, we'll take it.
I'm grateful.
Thank you.
I'm sorry, I was unaware of the in-camera proceeding.
How can we be? Why should we be? That's why we just told you directly. So please don't mind saying that. 7.
For the respondent number 1.
For the appellant, defendant appellant, my lord, their application for my lord, withdrawal of the deposited money in terms of
Your application.
My
Eviction suit.
put for eviction and recovery of money. I have submitted
Money regarding arrears of rent.
areas of rent, contractual areas of rent, and main profit, 3 elements. So court has directed recovery of possession and eviction and recovery of money. Certain amount has been decreed. We preferred the appeal and deposited the decreed amount before this honorable court in terms of your lordship's court order dated 13th October 2020. That was kept in a fixed deposit. 2020.
20. Achha.
Within the time with the court, my lord.
Yes.
So they have, in the meantime, my lord, we have settled the matter, my lord, so far as possession, and we have handed over possession. 31st July, we have handed over possession.
Then we'll allow this application.
Only one rider, my lord. We said in the plaintiff also it is admitted that rupees 3 lakhs security deposit was lying with them, interest security deposit was lying with them, which shall be returned at the time of.
That will be adjusted, you say.
That was not in the decree.
3 lakh.
That 3 lakh was not adjusted.
So we'll direct that to be adjusted. That is.
My instruction is that
You are agreeable. Great.
We have deposited the sum of, they have stated in the opposition to the.
So then the appeal gets disposed of. It has been already disposed of.
No, appeal is pending.
So we'll record that we dispose of the appeal in terms of such settlement between the parties. Why keep it pending? Can 5 is the only pending application. Very well.
For withdrawal of the money. For withdrawal of the money, only this amount is to be adjusted.
Yes, we'll put that in. Definitely. Yes. Can 5 of 2024 has been filed by the plaintiffs stroke respondents for withdrawal of the decretal amount which has been deposited by the defendant appellant with the Registrar General of this court as condition for grant of stay at the initial stage of the appeal. Who's up next para? Learned counsel for the parties submit that the matter has been settled between the parties and the appellant has already handed over peaceful and vacant possession of the suit premises to the respondents, comma, which is agreed upon by learned counsel for the respondents. Who's up next para? Learned senior counsel, sorry, Learned counsel for the appellant submits further that the security deposit of rupees 3 lakh, which was initially uh, paid by the appellant to the respondents, comma, be adjusted from the amount sought to be withdrawn by the respondents. Full stop, next para. Learned counsel for the respondents, comma, on instruction, comma, agrees to such proposal. Full stop. Accordingly, we dispose of Can 5 of 2024 by granting liberty to the respondents to withdraw the amount deposit, withdraw the deposit decretal amount along with interest, comma, which was deposited by the appellant at the inception with the learned registrar general in connection with the present appeal, comma, upon deduction of the amount of rupees 3 lakh, comma, which will be returned to the appellant by the learned registrar general upon the appellant so approaching. Full stop, next para. Accordingly, the learned registrar general shall, comma, as and when approached by the respondents or through their authorized representative, comma, disburse the decretal amount deposited by the appellant along with interest accrued till date, comma, by deducting rupees 3 lakh to the respondents. Full stop, next para. The retained amount of rupees 3 lakh shall be returned to the appellant or the appellant's authorized representative as and when so approached, comma, by the learned registrar general. Full stop. The entire refund as directed above shall be subject to deduction of the statutory dues by the learned registrar general of this court. Full stop, next para. All concerned shall act on a server copy of this order without insisting upon prior production of a certified copy. Full stop, next para. No order as to cost. In view of the above order, and since the appeal has already spent its force by resolution between the parties amicably, comma, FAT 237 of 2020 is disposed of in terms of the settlement arrived at between the parties as indicated above. No order as to cost. Why not today? Move the matter. So what? You are there. Move the matter.
Brief in the chamber. Brief is in the chamber.
I was served on the principal respondent. That was the, and you have to cure the defect. Defect is also not cured. What defect? What is the defect? Delay. Oh. Can want a section 5 করেছে না কিন্তু আরো কিছু ডিফেক্ট ছিল মনে হচ্ছে 18 ডিসেম্বরের An adjournment is sought on behalf of the appellants. Full stop. Next para. Accordingly, let the matter stand adjourned for the day. But don't pray for adjournment tomorrow. You must come prepared. If he's not there, you have to move the matter and come prepared with your affidavit of service.
This matter, my lord, I'm filling up replacement of one.
Yes.
Seeking some accommodation, can you keep it on 29?
Why accommodation?
Some documents are illegible. I advise.
What is the matter about? What is the application for?
Application, first application there, me. I am, the fact is this.
Stay of what sort of a decree?
Lordship has stated the order
Oh, that stay order is there.
Partly.
till disposal of the application, your lordship. Stay is there, and lordship has directed the respondent number 1 to file a position.
That has not been filed. For that you are wanting time.
That I am seeking accommodation for that.
But it was directed long back, 9th of December.
That is some illegible documents. I'll advise to the client to give that document.
How soon can you file that, Mr. Garg?
By 29?
By?
29?
By 29th?
Yes, Milo.
Learned counsel for the respondent number 1 seeks further extension of the time to file affidavit in opposition. Full stop. Accordingly, the time for filing opposition is extended till January 30, 2025. Full stop, reply, if any, shall be filed by February 6, 2025. Full stop, the application shall be listed for hearing on February 10, 2025.
Next minute, the name of the junior is only gone minute. That is written.
Give it properly, it will be recorded properly. You give it properly and in legible handwriting, it will be recorded.
Okay.
Yes.
My lord, I am appearing for the petitioner. Mr. Chayan Gupta is appearing online, my lord.
Online, yes. Mr. Chayan, we see Mr. Thakkar, not Mr. Gupta.
I appear for respondent number 2, please, my lord.
Oh,
I'm being led by him.
oh, Mr. Gupta is not there. You start the matter.
Please, Mr. Gupta is also there. I see him on the screen.
Oh,
My
he's
lord,
covered by the Hindu Succession Act in before us. But he can. Mr. Gupta, are you there? Can't hear him.
my lord, on 17th, we have received the objection filed by the respondent number 2 and 3. Now I am praying for a direction to file affidavit in reply to that objection.
17th you have received. Yes, Mr. Gupta will give you another week's time to file reply.
I'm grateful. We would need a week's time.
Mr. Thakkar, any difficulty in that?
No difficulty, my lord. Not at all.
Very well. On the prayer of the appellant,
I'll file mine.
yes, opposition. As a affidavit in opposition, affidavits. Affidavits in opposition filed to be kept on record. Full stop, on the prayer of the appellant, comma, the time for filing affidavits in reply thereto is extended till January 27, 2025. Full stop, the applications shall be listed for hearing on January 29, 2025. 29 January.
Can it be 30th instead of 29th?
Yes, yes,
please?
30th. No difficulty.
Great.
Returnable on January 30th, 2025.
Grateful.
30th January. Thank you. Thank you. 7 হয়ে যাবে অ্যাপিলটা ওই জন্য সবাই চলে এসেছে Yes.
My lord, I'm appearing for my lord respondent. My lord.
Yes, Paul. Mr. Chakraborty, you are for the appellant? Yes, what is the matter?
My lord, in connection with
this
the
is my-
matrimonial suit, my
What is
My
it?
reply to affidavit in a supplementary.
Opposition you have already filed?
opposition file, my lord.
No, this is your opposition.
My lord, this is my opposition to
Oh,
supplementary affidavit.
your reply, Mr. Chakraborty?
Huh?
Reply to this.
The reply I'm giving to the opposition file there earlier. My lord, matrimonial appeal, my lord.
Sir, Chakraborty, please give us half a second. There's a supplementary affidavit by you also. So let us find out the opposition and everything. Supplementary affidavit.
My lord,
This is in connection with CAN 1.
yes.
CAN 1 is
Can you
for condonation of delay. Acha, CAN 1, let us find the opposition, the pleadings first. Very well. CAN 1, there is an opposition and your supplementary affidavit. This affidavit, your opposition was a composite opposition to this supplementary also.
My lord.
Acha, very well. Yes, Mr. Chakraborty, what is it?
My lord, judgment in the trial court was passed on 28th of June 19. 2000.
What is the delay about?
Delay is, my lord, 791 days, my lord.
7921.
791 days. My lord, I have stated the reason.
No, no, 791. 791. What is the reason for such a long?
My lord, first of all, my lord, the judgment was passed by the trial court on 28th of June 2019. My lord, my father was very much ill on that period of time. My father died, my lord, within a period of 3 months thereafter, my lord. On 12th of September 2019, my father died, my lord. My lord, thereafter, my lord, I have lost my job also, my lord. I have lost my wife. I have lost my father. I have lost.
Lost your wife means?
I mean, wife left. Wife left. My
She obtained a divorce degree.
my lord, see, no, we filed.
This is against a divorce degree.
Just
My lord.
one
You did not lose your wife
My lord, one and
in the sense that you lost your father.
No. 1.5 months he remained with me.
That is on the merits, Mr. Chakraborty. What is the reason for the delay?
I'm saying mental,
791 is too much.
mental condition, I am saying.
Mental
That-
condition, if that be so, after passing judgment in every matter, the judges would have to
I
retire.
was totally upset because, my lord, my wife left away. My father.
We
left-
appreciate that, but this is
my,
not a
my
ground.
father left, my lord.
When did your father die?
My lord, father died, my lord, on 12th of September, just within 3 months from the date of my lord divorce.
Which year?
2019.
2019. Yes.
2019.
19.
2019. My lord, thereafter, my lord.
A divorce degree on?
Divorce decree on, my lord, 28th June 2019.
28th.
28th June
3 months
2019.
earlier, after
20 or 28?
28th.
28 June, my 28th June, the judgment passed. Father
Passed away on 12th of September.
12th of September.
Then you got upset.
My lord, thereafter, my lord, the coronavirus was there. And my lord,
Coronavirus came much later.
yes, my lord.
You
my-
were upset for 6 months
and
before
then
Corona
my-
came.
I lost my job also. My lord, I became jobless. And my lord, these 3 events that happened in my life. My lord, wife, I had to leave.
When did you lose your job?
My lord, job, my lord, in between, my lord, I have stated that I have got the job in 2023. 23, my lord.
When did you lose it?
My lord, কবে lose? Huh?
Because that is the reason for your delay. One of the reasons.
Yes, my lord. One of the reasons in between, my lord, I have lost the job.
In between, we want to know the dates. Otherwise, we cannot. You lost your job. We appreciate that, the difficulty in that. But when?
Para 7 of the
Supply.
not para 7
Lord,
of the
my lord, I have
section
stated
5,
that after petitioner got an employment in the year 2023 and gradually recovered the same to some extent from the financial disability and thereafter contracted with learning advice. This is, my lord, 3, my lord, set up in my life in this in phase, and in between my coronavirus was there. My lord, my lord, my wife left. My only 1.5 months she remained with me. My lord, kindly see the
Any issue? There is an issue?
no. No,
Mr. Chakraborty, this is not sufficient ground. Being mentally upset for 6 months.
no,
And you have not even stated when you lost your job.
day-to-day explanation, my lord, have not been
no,
given,
not,
my lord.
my
Not
lord,
required.
if-
Day-to-day explanation is not required. That is the law.
my lord, if,
But
my lord,
at
lost
least
the
one,
job,
the
if
date
you
of
lost-
losing the job should be there.
if the date of losing job is, my lord, relevant, my lord, I shall file the same, my lord, by
No,
file.
no further time.
No,
We
my
have
lord,
given
then-
you, no.
No, my lord,
We have
then,
permitted you to file a supplementary, no.
then,
You
my lord,
cannot drag on.
on basis of that, my lord, you kindly,
No, Mr. Chakraborty, not
So
sufficient.
kindly see
Sorry.
that, my lord, your
are
lordship
dismissing
have
this.
passed judgment, my lord,
My lord,
that
may
marriage
I-
irreparably broken, my lord, kindly see, since my 2000,
He has obtained a divorce decree,
no,
dismissed.
dismissed. That's why I've lost the wife. I am saying that my wife, I lost the company of the wife. She left. You know, kindly see the setup in my life. Wife
But
left.
791 days delay, there is no explanation at all.
In the meantime, my lord, there are 2 years from Corona. That is also, my lord, to be taken into consideration. And my lord, these 3 events, my lord, these
Corona cannot be taken into consideration unless the cause of action arose in between Corona.
in
Otherwise, no.
between my Corona, my lord,
No. It appeared long. The cause of action arose when the decree was passed on 28th of June 2019. So
Yes.
September it expired.
I know.
2019. 6 months before start of Corona.
September, father died, my lord.
Other date is not a ground for not filing a
My
bill.
lord, kindly see what happened. If my father dies, my lord, whether it is a proper time for me to file, my lord, appeal, my lord, kindly see. Father died at that relevant time, my lord. Whether I am asking myself whether that is the proper, my lord, courage, there is courage for me to file appeal. My lord, kindly see this setup.
Much
my
courage is not required to file a
lord.
file.
My lord, much courage.
Unless your client was afraid of approaching you, Mr. Chakraborty. Otherwise, where is the courage required?
He lost the job also, my lord.
You have not stated even when.
My lord, I've stated I've got the job, my lord, exact date.
You have got the job in 2023. When you lost it, how do you know? Maybe for the first time you got a job in 2023. How do you know?
My friends kind know, my lord. I have lost the job.
Let her know. But you have to know also. If your friend's client, that is your wife, knows when you lost the job, isn't it obvious that you
kindly
should
see-
know yourself?
My lord, I have stated, my lord.
This
that
is absolutely a frivolous ground, lost job. Because you have not stated the date,
Well,
you
I
need
have
a
also
supplementary.
stated my paragraph 4. I also became very much ill and suffering from mental depression.
Any treatment for mental depression, Mr. Chakraborty?
Depression, my
Any treatment, any doctor certificate?
doctor certificate not readily available. Depression and
How can it be
also
available if you are not clinically depressed?
the depression, my lord, these events,
791
my
days,
lord,
right?
kindly
Yes,
see
just
the
one
events,
question.
my lord, that has taken place. My lord, suppose, my lord, it is dismissed. I am to file a fresh suit, my lord.
If there is fresh cause of action, you can file.
Then again appeal, my lord, life will be totally destroyed, my lord. If I to cross my lord trial court and appeal court, my lord, there will be nothing remain in my life, my lord.
When did you file this appeal?
Appeal has been filed, my lord. 2023, my lord, it has been filed. My lord, affirm on 19th of October, 2020, my lord.
No question of affirming. When was the appeal filed, memorandum?
My lord, same date, my lord.
Achha, 19th of October 2023.
Yes.
When was the corona period over? Corona moratorium, Mr. Chakraborty?
February 22.
February 22.
Yes.
So what were you doing from February 22 to October 2023?
There had been some correspondence, my lord. My kindly see that, my lord, I stated my
That is correspondence required. This is not a money suit. From February to February, that is 1 year and 8 months. 1 year, 8 months after the corona.
I negotiated for my mutual divorce, my lord. Thereafter, my lord, she replied that whatever mistake I have committed, I am sorry. I want to join you. This is the stand, my lord. After waiting,
He's still willing to join you because your divorce decree has been dismissed.
My lord, dismissed, suit dismissed in 2019 and correspondence in 2023. In between, she made no venture to meet me. When I gave letter in 2023 that when you are not meeting me or joining me, you let us arrange for mutual divorce. Then, my lord, she stated that no, whatever mistake I have committed.
Where have you stated this?
My lord, kindly paragraph, annexure B, page 9. Annexure B, page 9. My lord, kindly see. আমি তোমার অপেক্ষায় এতদিন ছিলাম, তুমি এতদিন পর যখন আমায় সুযোগ দিয়েছো, তাই আমি তোমায় চিঠি লেখার জন্য সাহস পেলাম। তুমি যখনই আমায় এসে নিয়ে যাবে, সেই দিনই আমি তোমার সঙ্গে যাব। স্বামী স্ত্রীর মধ্যে অভিমান কি বেশি?
So she wants to come back to you.
My lord, after just when I proposed through my common friends for mutual divorce, then this letter has been given.
No.
My lord, 2019 from 2023, these and my lord, suit filed, my lord, kindly see in which year. 2014 suit filed, and now we are 2023. My lord, I have come across the judgment passed by your lordship that
irretrievable breakdown can happen only if there is a valid suit pending.
Your lordship has, my lord, passed judgment.
This section 5 is not allowed.
Taken into account, that has been taken into
account. That's in a valid appeal. You have not filed an appeal for 7 months.
Meritorious appeal, my lord. Meritorious appeal, my lord. Delay, my lord, is to be condoned, my lord.
That position has changed now. Justice Belathi with his judgment. That position changed now. Justice Pardiwala's judgment also. That is not the position of law now. Merit need not be looked into. That is the current.
That's true, my lord. But here, my lord, the peculiar facts and circumstances of the case that I am, my lord, still 2014, my lord, proceeding with this matter, my lord. And she is, my lord, she has departed me, my lord.
791 days.
My lord. About 2 years, my lord. About 2 years, my lord. In meantime,
Heard learned counsel for the parties in support of the application, in support and against the application for condonation of delay in preferring the appeal. The appellant husband's suit for divorce was dismissed on June 28, 2019, against which the present appeal has been preferred on October 19, 2023. The delay is of about 791 days. Next para, learned counsel appealing for the appellant argues that the father of the appellant met his demise on September 12, 2019, just before expiry of the limitation period for filing the appeal. Next para, the appellant has pleaded in the application under section 5 as well as the supplementary affidavit filed in connection therewith that the appellant was severely depressed and as such, comma, was not in a position to prefer the appeal. Full stop. Thereafter, the corona pandemic included, and the appellant was also out of a job. Full stop. The appellant got back his got another job in the year 2023. Full stop. Next para. It is further submitted on behalf of the appellant that in the interregnum, comma, talks of settlement were going on between the parties. Full stop. Learned counsel for the appellant alleges that the respondent wife did not return of her own to the appellant, for which a communication was made by the appellant husband. Full stop. In reply thereto, comma, the respondent wife allegedly gave an answer in writing on July 28, 2023, which is annexed at page 9 of the application for condonation of delay. Full stop. It is thus submitted that the marriage between the parties has broken down irretrievably and there is considerable merits in the appeal, comma, for which the delay occasioned in preferring the same ought to be condoned. Full stop. Next para. Learned counsel for the respondent seriously opposes such prayer and points out that the prolonged delay in filing the appeal has not been explained at all. Full stop. Apart from the day-to-day explanation not being given, comma, the relevant dates have also not been mentioned in the application or the supplementary affidavit. Full stop. Next para. Upon hearing learned counsel, comma, we are of the view that the appellant has failed to give sufficient explanation for the delay in preferring the appeal. Full stop. The impugned decree was judgment and decree were passed on June 28, 2019. Full stop. The limitation period expired after 90 days thereof. Full stop. Next para. Even after the expiry of such limitation period, in or about the month of September 2019, comma, the appellant had about 6 months time before the onset of the COVID-19 pandemic in the due to which the lockdowns started round about the beginning of April 2020. Full stop. Next para. The pandemic restrictions ended in the year 2022. Full stop. It is an admitted position as it transpired during hearing, comma, by the appellant that the lockdown restrictions ended in or about February-March 2022. Full stop. Next para. We find that the appeal was filed more than 1 year, 7 months, even thereafter. Full stop. Next para. There is nothing on record to show that the appellant husband was suffering from such serious clinical depression that he was not in a position to prefer an appeal. Full stop. Moreover, comma, no date has been given in the application as to when the appellant lost his job. Full stop. Although day-to-day delay is not required to be explained, comma, at least the relevant periods and the dates which are germane in such context are required to be put in the affidavit in support of the condonation application, comma, which are seriously absent in the present case. Full stop. Next para. Hence, comma, not only was the husband delayed in preferring the appeal for about 6 months after the expiry of limitation before this commencement of the pandemic lockdowns, comma, even thereafter he lost more than 1 year, 7 months for preferring the appeal without any rhyme or reason. So, next para. The argument that despite his efforts, comma, no reconciliation could take place is neither here nor there and could not be a valid ground of preferring the appeal late. Full stop. Next para. Rather, comma, the purported letter of the respondent annexed to the application for condonation of delay brings out the wife's intention to resume conjugal life with the appellant in consonance with the dismissal of the husband's suit. Full stop. Thus, comma, we do not find any cogent reason for the long delay of about 791 days in preferring the appeal. Full stop. Thus, comma, there is no scope of the court looking into the merits of the appeal, comma, if it were to be entertained, comma, at length. Full stop. In view of the above, comma, can 1 of 2023 is dismissed on contest, thereby thereby holding that FAT 399, thereby dismissing FAT 399 of 2023 as time barred. If there is any other application, Mr. Chakraborty, no?
Some opening be given so that I can file the suit, my lord.
No, we cannot give any opening. If there is, you know the law. If there is subsequent cause of action, only then you can. Next. Yes. Yes, please. What is the matter?
Can four.
Oh,
Can four is
Alimony.
for alimony. Earlier occasion, yes, Lordship on 12 December taken up.
Who is appearing for the other side? Respondent husband was to file.
Earlier, or last order. Earlier occasion, he is not.
Yes, he was appearing. They were to file their opposition and affidavit of asset. Have they given any copy to you?
Yes, you got it. I've given copy, both the application copy.
You are for the respondent.
I've got equally.
You had filed your application
They have not filed any.
and you also filed your affidavit of assets. No. Have they handed over any opposition? That is what we are asking.
No, not yet. Not yet. Not yet, man.
Can you please just give one notice to them? We'll keep it tomorrow. Give a notice in writing. If they don't appear tomorrow, we'll grant it ex parte. None appears for the respondent at the time of call. Full stop. We find from the order dated December 24, 2024 that already the petitioner wife has filed her alimony application and the affidavit of asset in support thereof, comma, as yet no affidavit in opposition or affidavit of asset has been filed by the respondent husband, despite a specific direction being given to file those within January 10, 2025. Full stop. As a last chance to the respondent to appear and contest the alimony application, comma, the matter is adjourned for the day. Full stop. The learned advocate on record for the petitioner shall give a notice to his counterpart appearing for the respondent, indicating that in the event the respondent does not appear tomorrow at the next call, comma, the matter may be taken up ex parte in the absence of the respondent.
I put tomorrow.
Tomorrow. It will appear tomorrow and give a notice today, Mr. Khanna, so that.
Thank you.
My lord, I appear for the respondent.
Yes, Mr. De. Mr. Ghosh, you are for the petitioner, right?
Appeal, Lord, here refusal of granting probate.
Yes.
Probate was applied for by the widow. Stepdaughter is contesting.
What is can to?
Lord,
Injunction
Lord,
application.
injunction. Lord, that is, they have filed their opposition, we have filed.
I am filing my opposition.
Lord, their opposition is mainly on the basis of merit, but so far position is concerned, they have not denied.
Probate was refused.
Yes.
Mr. De, why shouldn't injunction be maintained? We can direct affidavit.
There is no merit. My lord, they have failed to prove the will. There is no attesting witness.
No attesting witness, not a single attest.
No. Attesting witness, one
I
died.
do not know. I have not signed. I have not signed.
Lord,
I have not seen
one
the-
died, 190 years old.
In a first appeal, Mr. De, as you know, all the questions are kept open.
My lord,
We can direct you to file paper books if you want.
No, that we shall not do. Why shall we get- But date may be fixed, my lord, for a year.
How can we fix a date unless they appeal? Because we can dispense with service, will dispense.
Suffer with injunction.
Mr. Ghosh, file the informal paper books within 6 weeks.
Yes.
We'll give it.
Building, my lord, so-
Pardon?
Lord, she is a professor, she resides
But
at
here the
Bojboj.
trial court records are required to come because it's
Yeah.
a probate.
Lord, she is a professor, resides at Bojboj. The daughter.
That's different.
I also
And it
live
is
at
at
Bojboj.
Chetla.
I also live there.
Learned counsel for the learned senior counsel appearing for the appellant argues that in view of a prima facie case having been made out and an ad interim injunction being granted on December 23, 2024, comma, the same be made absolute. Push up next para, learned counsel for the respondent opposes such prayer and argues that the appellant has not made out any prima facie case. Push up, it is further pointed out that the probate application of the appellant was refused by the first court in view of the purported attesting witness having failed to prove the will, prove the execution of the will. Full stop, next para. However, comma, since both questions of fact and law are involved in a first appeal, comma, it would be premature at this stage to shut out the appellant from making arguments on merits of the appeal, comma, particularly since the appeal is not yet at the hearing stage. Full stop, next para. Accordingly, can 2 of 2024 is allowed on contest, thereby thereby restraining the defendant respondent by an order of injunction from selling, transferring, alienating, encumbering, and/or creating any third-party interest in respect of the suit property, which is the subject matter of the disputed will, and/or from disturbing the possession of the plaintiff appellant in respect of the subject property, comma, till disposal of the appeal. Full stop. Next para. The affidavit in opposition and reply filed today be kept on record. Full stop. Next para. There will be no orders to cost. Next para. In view of appearance of the respondent through her learned advocate, comma, service of notice of the appeal on the respondent is dispensed with. Full stop. The trial court records be brought by special messenger at the cost of the appellant to be deposited within a week from date positively. Full stop. Upon the trial court records arriving, comma, being examined and found to be complete, comma, a notice of the appeal shall be served on the learned advocate for the appellant. Full stop. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of such service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list for hearing as and when the same is made ready for hearing. Thank you. Yes.
The appellant.
Yes, Mr.
The
Mukherjee.
matrimonial appeal, your lordship was pleased to pass an order. But, when I took out an application for stay, my learned friend came up with a certificate of marriage saying that he got remarried under the Arjasham Act.
Yes.
So, I challenged the certificate of marriage to say that there was no provision to get this marriage certified in the manner that they claim to be. Now, on the last occasion,
So, manager, please take your seat. We'll just.
on the last occasion, your lordship was pleased to pass an order. Your lordship will find that order at page 5 of their supplementary affidavit.
You are not using anything to the supplementary affidavit?
Yes, I am, I am. This is a rejoinder, if your lordship comes to the...
Which page of the supplementary?
Page 5, my lord's order.
Page 5 of...
they are supplementary, this is...
affidavit.
Mr. Shumon Mojumdar, advocate, his back.
Yes, yes, yes. Page 5. Page 5, yes.
Your lordship has, in the first 5-6 paragraphs, your lordship has recorded the facts are. Then at paragraph 6, page 7, upon hearing the learned counsel for the parties were prima facie of some doubt as to whether the certificate annexed at page 72 of the affidavit in opposition is valid and proper certificate of marriage. This was then your lordship recorded why your lordship is expressing doubt. At this juncture, I'll request my lords, to kindly open page 72, the certificate. And thereafter, I will take your lordship, to what their contention is.
72 of the opposition.
But this is the only document that they produce in support of that.
They had to explain that why the district magistrate gave it and this
in
compulsory
support of
marriage
that,
order, whether this comes under.
Now that they come up with
Yes.
a Delhi Gazette notification that your lordship will find at page 9.
Page 9 of?
Page 9 of the supplementary that your lordship was looking at. Or your lordship may kindly look at page 15, the English version of it.
Yes, page 15.
Now, this is order dated 2014, 21st April. This was pursuant to Srimati Shima vs. Oshini Kumar, pursuant to the Supreme Court judgment of registration of marriages. Now, this says 1B, this order shall extend to all marriages solemnized in Delhi, irrespective of caste, creed, and religion professed by the parties to the marriage. This is a very secular order. This is not another Hindu marriage. Then, my lord, compulsory registration of marriage. Then, my lord, the marriage officer, for the purpose of compulsory registration of marriage in accordance with this order, the marriage officer already appointed for registration of marriage under the Hindu Marriage Act, Special Marriage Act, or any other law for the time being in force in Delhi shall have the jurisdiction to register marriage under this order. Also, provided that government of NCT of Delhi may appoint additional marriage officers for the purpose of this order and may also delegate power of marriage officer to any retired gazetted officer appointed for this purpose for such period not exceeding 5 years after his retirement and having not attained the age of 65 years. Now, my lord, the important is the procedure. Lord, why I place this, Lord, I'll relate later on. Within a period of 60 days, excluding the day on which the final ceremony of marriage is solemnized, the parties to the marriage shall apply jointly in prescribed Form A for registration of their marriage addressed to the marriage officer, having jurisdiction to register the same. Such prescribed application shall be accompanied by documentary proof of age of both the parties to the marriage, solemnization of marriage, identification of the parties, place of residence of the parties to the marriage, citizenship of the parties, if any, along with the requisite fee of ₹200. On receiving such application along with the requisite document as prescribed above and satisfaction of the marriage officer as regard authenticity of such proof, the same shall be entered in the register of marriage prescribed for the purpose as per Form B. This is a statutory form. After having received such application complete in all aspect and having entered the same in the prescribed register, the marriage officer shall fix a date for the parties to appear in person along with two witnesses who shall certify to the solemnization of such marriage and bearing proof of permanent resident of Delhi. The marriage officer thereafter on personal appearance of the parties with witness on such appointed date or any other extended date and on satisfaction of solemnization of such marriage in Delhi shall issue the requisite certificate of registration of such marriage as per Form C.
Yes.
So, my lord, the Form C according to them is, my lord, page 72. Now, my lord, assuming, then, my lord, 5, jurisdiction of marriage officer. The marriage officer within whose district the marriage has been solemnized shall have the jurisdiction to register the marriage, provided that subdivisional magistrate headquarter, additional district magistrate and district magistrate of Delhi shall have concurrent jurisdiction over entire Delhi to register any marriage solemnized in Delhi within the revenue district of Union Territory of Delhi. So, my lord, the named, my lord, the marriage officers and, my lord, this 3 classes of, my lord, persons.
Yes.
Now, my lord, the 8, registration of marriage under this order will not tantamount to validity of marriage as the same would be the subject matter of the respective law, custom and practice professed by the parties as applicable to such marriage. Therefore, this is not a conclusive proof of a valid marriage, the certificate. Now, my lord, Form A, this particular Form A is required, my lord, to be submitted by the parties which is not before your lordship. This is a statutory format. Without the statutory format being submitted, the Form C certificate cannot be issued. Even if I assume, Lord, the gentleman who had issued the certificate does have the power to do.
But this is an official act. If a Form C certificate is issued, carries a presumption of correctness.
That is not, Lord, the validity. 8. Kindly see.
Yes, 8 says registration of will not tantamount to validity of the marriage.
Yes.
The validity of their marriage is not under challenge in a suit.
Lord,
here we are to prima facie being satisfied that there is a presumption of correctness is there.
Lord, not in this case. Why? It carried a presumption of validity, Lord, in case of a special marriage act. Because the law there said that on production of the certificate, there is a presumption of valid marriage. Because the nature of the marriage under the Special Marriage Act is not generally a certificate.
Mr. Mukherjee, in a special marriage, the registration is the marriage. But in a Hindu marriage or Arya Samaj marriage, which falls under Hindus, then registration itself is not the marriage. It just signifies that there is some presumption that they have carried out a valid marriage under their customs. And this certificate says so, that according to the custom and practice, which is in consonance with the language of this order.
Lordship.
So, therefore, there is a presumption that there is a Hindu marriage between them according to their customs.
Lord,
both are Hindus.
My argument is, Lord, this has been a procured certificate. Why I say this? But first of all, they have failed to produce before your lordship the form because the certificate was issued on 3rd of July 2024.
Yes.
And the certificate itself says, my lord, that the solemnization was done on 2nd, the previous day. Lord, your lordship will find that, my lord, after the photograph of the lady,
Yes.
the second line have been solemnized at Arjo Samaj Mandir with Bibaho Bandhan Trust.
Where do you find the date
Lord,
of?
after the photograph of the lady at page 72.
No, this certificate was issued when? It says that 3rd it was registered, all right.
Yes.
Arjo Samaj Mandir, there it says.
Arjo Samaj Mandir, Bibaho Bandhan Trust.
Mr. Mukherjee, can it not be that in terms of clause 4D, after having received they married on 2nd, applied the same day, and the next date was fixed? Is it impossible?
That is the reason, Lord, I read, Lord, the procedure.
Yes.
Application, there must be a subjective satisfaction. Then, Lord, the form C can be issued.
Let us take the best case in their favor.
The proximity of the date, that is the reason, Lord, that it creates a doubt in our mind about the veracity of, Lord, the
But there
form.
is no bar in it happening the next day, because within 60 days they have to apply. They may apply the same day also.
Lord, that is what, Lord, that they have not produced before your lordship.
We cannot go behind the certificate. It carries a presumption of correct
But
official
I say
act.
that the certificate has not been not granted lawfully. Because when we look into this rule, the rule says that after the application is made in Form A,
Mr.
there must
Mukherjee
be an
will
inquiry.
say that there is prima facie, there is
Some lordship has already said that the marriage will be subject to my rights under the appeal.
will make that prima facie absolute.
That your lordship may do, but what my apprehension
But yes,
is
this it will be kept open to be argued in the appeal whether there is a valid marriage.
What I mean to say,
We'll keep that
in
open.
the meantime, I pointed out, if that they regularize, they will come up with the plea that I have already got a valid second marriage.
No, that is precisely what we propose to do, Mr. Mukherjee. That is what we say. We say that we'll keep it open for being argued at the final hearing. We do not conclusively say there is a valid marriage, but we will say that we find sufficient prima facie evidence that there has been a second marriage for which you refuse to grant to stay. But
they claimed second marriage, your lordship, because
well,
the marriage is not admitted by me, or your lordship will decide
Right.
whether the second marriage is a
And
valid
if you
marriage.
want, we can
It is
we
a
can
claim
direct them
marriage,
not to enter into any third marriage also if you want.
That your lordship may not kindly restrain my lordship. Second marriage is valid for third marriage.
We don't know. If you find any such, if there is any such presumption, then come back and we'll pass
My
it.
client says that there might be that because of the fact that we are not doubting about the second marriage.
Yes.
They might not come up with somebody to say that no, I have lawfully married. That is the apprehension of the client. I don't
So,
say
who will come up and say
that I have married somebody else. Well, this is not a valid marriage.
a third? No, don't name anyone. So, Banerjee, don't name it. We'll do that, Mr. Mukherjee. We'll refuse, and we have heard Mr. Banerjee. We have heard.
Yes.
Heard learned senior counsel appearing for both these parties. First up, a dispute has arisen as to whether the respondent husband has contracted a second marriage, which is taken as a defense by the respondent husband to the present application for stay of operation of the impugned divorce decree in the appeal. First up, next para, learned senior counsel appearing for the petitioner argues that the purported certificate of marriage, annexed at page 72 of the affidavit in opposition of the respondent, is not a valid marriage certificate. First up, next para, the respondent has relied on an order of the Revenue Department of the Department of Law, Justice and Legislative Affairs of the National Capital Territory of Delhi, under which the marriage purportedly took place, marriage purportedly was registered. First up, next para, learned senior counsel appearing for the petitioner argues that since an Arja marriage has been alleged to have been contracted between the respondent and a third party, comma, the same comes within the purview of the Hindu Marriage Act. Push up next para. It is pointed out on behalf of the appellant that as per clause 1 of the Revenue Department order dated April 21, 2014, comma, the provisions of registration of marriage under the said order O capital hobe subject order are secular in nature and not confined to Hindu marriages, and as such, comma, there is some doubt as to whether the same tantamounts to a marriage registered within the provisions of the Hindu Marriage Act. Push up that apart, comma, it is pointed out that in terms of the procedure laid down in clause 4 of the said order, comma, within 60 days of the final ceremony of marriage, comma, an application has to be filed for registration in form capital A. Pushed up in the present case, comma, it is submitted, comma, no such form A has been produced, which casts some doubt on the authenticity of the marriage and the certificate of the same. Pushed up again, comma, in subclause small c within bracket of clause 4 of the said order, comma, on receiving the application along with requisite documents, comma, the marriage officer is required to enter the same in the register of marriage prescribed in form B, pushed up next para, as per subclause small d, comma, thereafter, comma, the marriage officer is required to fix a date for the parties to appear in person along with two witnesses who shall certify to the solemnization of such marriage and bearing proof of permanent residence of Delhi. Push up next para. As such, comma, it is submitted that in view of the marriage having purportedly taking place on July 2, 2024, and having been allegedly registered on the very next date, even as per the purported marriage registration certificate produced by the respondent, comma, serious doubt is cast as to whether the said certificate is a proper certificate issued under the order in question, O capital order. Next para, lastly, it is argued that clause 8 of the order provides that the registration of marriage under this order will not tantamount to validity of marriage, as the same would be the subject matter of the respective law, comma, custom and practice professed by the parties as applicable to such marriage. For sub next para, learned senior counsel appearing for the respondent stands by the provisions of the Revenue Department order and contends that there is no infraction of the said order in the present case. Footstep next para, the timelines as specified therein are alleged to have been adhered to by the parties. Footstep, it is submitted that the production of Form A or Form B is not a prerequisite for the court taking a presumption of correctness attached to the certificate which has been issued in the performance of official duty by the concerned district magistrate. Footstep next para, upon hearing learned counsel for the parties, comma, we find that the second marriage of the respondent has been sufficiently proved, comma, at least at a prima facie level in order to refuse stay to the appellant hearing. Footstep next para, it is found from clause 5 of the Revenue Department order that the same also confers concurrent jurisdiction on the concerned district magistrates of Delhi to register any marriage solemnized in Delhi. Pushed up that apart, comma, although the urgency with which the respondent contracted the second marriage is evident from the dates of the alleged marriage and the registration thereof, comma, we do not find that by such very urgency, comma, automatically it can be presumed that the timelines as provided in clause 4 of the Revenue Department order dated April 21, 2014 were not complied with. Pushed up, we do not find it impossible that whereas the marriage took place and solemnized as per the Arjo Samaj norms, comma, which comes within the purview of the Hindu marriage. Hindu norms only. which comes within the purview of Hindu rights and customs,
The marriage was conducted according to Hindu rights.
comma, we also find that the same could very well have been applied for to be registered the same day and registered on the following day upon due compliance with clause 4. Full stop. Next para. Moreover, comma, from the certificate itself, comma, it is clear that the marriage was solemnized at the Arya Samaj Mandir Vivah Bandhan Trust, but according to the custom and practice of the parties. Full stop. The custom and practice of the parties, comma, both of whom are Hindus, admittedly Hindus, comma, obviously refers to the rights and customs as contemplated in the Hindu Marriage Act. Full stop. Hence, comma, sufficient, arekta line add kor. Insofar as clause 8 of the said order is concerned, comma, although the registration of the marriage might not itself tantamount to validity of the marriage, comma, particularly if performed under the Hindu rights and customs, comma, the same definitely creates a presumption as contemplated in the Hindu Marriage Act of a valid marriage having preceded such registration. Full stop. Next para. Thus, comma, we find that a sufficiently strong prima facie case of a second marriage of the respondent has been made out. Full stop. Accordingly, comma, it would not be prudent at this juncture to grant a stay of the impugned divorce decree, comma, which could upset a probable valid marriage which has been contracted by the respondent in the meantime. Full stop. Next para. Accordingly, can 1 of 2024 is dismissed on contest without any orders to cost. Full stop. However, comma, it is made clear that the validity of the alleged second marriage of the respondent can be argued upon by both sides at the final hearing of the present appeal. Full stop. Next para. The observations made above are not conclusive as to the validity of such second marriage of the respondent beyond doubt. Full stop. Next para. The in view of appearance of the respondent through the learned advocate, service of notice of appeal on the respondent is dispensed with. Full stop. The trial court records be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. Upon the service of notice of arrival of the trial court records on the learned advocate for the appellant, comma, the appellant shall prepare and file the requisite number of paper books within 8 weeks thereafter. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Great request, my lord. You were also telling me. Your question is, my lord, whether, my lord, as a third party, my lord, to what extent, my lord, can she, my lord, challenge, my lord, the, my lord, if,
I am not.
No, Mr. Banerjee, if he succeeds in proving that there is no second marriage, then because that will be a relevant consideration when we finally dispose of the appeal. If you have contracted the second marriage, we may proceed on a different footing.
But it's section 15 of the Hindu Marriage Act, where I'm
Is there.
excited to take that point. Section 15.
Is that point he can take?
I can always take it.
Yes, yes, there is no doubt on that.
Married within the period of not the appeal.
Yes, yes.
yes, my lord, my lord,
No, all points.
suggested, my lord, but I just thought, my lord, perhaps
No, no.
something which.
Kept open means no
yes,
conclusive
yes,
observation.
yes,
Kept open
yes,
means both of you observe.
yes. Probably argue with.
Grateful.
Grateful.
My lord, I appear for the appellant in this matter. I'm
Yes,
request
sir.
Mr. Shuddha Banerjee.
Yeah.
Your lordship kindly passes it for 10 minutes. He's on legs. Just
Then, Mr. God, it will be difficult to pass over and.
he takes it up.
Yes, Mr. Banerjee, you are for the other side.
My lord,
Your
I just-
expression is clear. Very well, pass over. Whenever both of you come, mention it. Pass over করে রাখুন। আমার কথা মুখ করে শুনতে দাঁড়িয়ে আছে, তখন অসুবিধা আছে। আগের দিনের টাইম
my lord, for divorce. But in that suit, my lord, the husband initially filed a counter claim also. The suit was
For divorce.
For divorce. The suit was dismissed. Therefore, miscase under of section 24 was also subsequently.
Was also?
Was also dismissed for default. Both sides did not. Thereafter, husband filed an application for recalling the reconsideration of the counterclaim. No notice was served.
That was also dismissed for default.
No, that was not dismissed. That proceeded ex parte.
No, he filed a recall for what?
For allowing him to continue the counterclaim application. But
Obviously.
that notice was also not served upon us. That continued ex parte and that was decreed, my lord, for divorce. Challenging we have come up before your lordship, my lord.
Yes, there should be injunction.
Yes. No problem about that. Mr. Aniruddha Mitra, my lord.
He's in court.
Yes, ma'am.
So we will dispose of the application.
I am coming with an application under 4127 because of the fact, my lord, the 498 day dismissed.
Definitely.
So that's why, my lord,
Cruelty.
cruelty because no further proof.
Admission is that.
And apart from that,
The evidence in that.
yeah, that then, my lord, the appeal may be taken up for hearing, subject to my lord's presence.
Yes.
I'm coming on the next week with this application.
Appeal along with that, how can it be?
I'm praying for that.
No, sir. How can it be? Records have to come in this.
Kindly consider one aspect.
Materials, we have to see the evidence and everything.
1 minute time. The subsequent evidence will be before my lord. That 498 proceeding has been culminated into a dismissal.
No, Mr. Basu, we do not express our views, but that may not be conclusive by itself. We want to look into the. No, but the evidence has to come from the trial court.
I am not on that, but I am submitting, my lord. Here, what is the case made out? The suit dismissed for default.
Yes.
No restoration paid for.
He has only challenged the counterclaim.
In
Counterclaim degree.
There is no evidence, no written statement available. So doctrine of non-controversy will apply.
We'll consider that.
Decree has been
We'll
passed.
consider that if further notice was not given, whether it will apply or not.
I
What
just
so you see? Particularly since you are appearing, it has to be made more difficult for you.
In shortest possible time can be disposed of. That's why.
You know, Mr. Basu, shortest possible time. If it is ready for hearing, we can do it in shortest possible time.
We will make it be ready for hearing.
We'll give you that liberty then. Very good. Since the present appeal is directed against a decree whereby the counterclaim of the respondent husband was decreed ex parte against the appellant, questions of both fact and law are involved, whose accordingly can 1 of 2024 is allowed, thereby restraining the respondent husband by an order of injunction from contracting a remarriage during pendency of the appeal. Next para, the appeal, in view of the appearance of both parties through their learned advocates, service of notice of the appeal is dispensed with, The trial court records shall be brought by special messenger at the cost of the respondent to be deposited within a week from date, Next para, the respondent shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, for the respondent. It is made clear that upon the records arriving, being examined and found to be complete, a notice of appeal shall be served on the learned advocate for the respondent for such purpose. Next para, liberty to the parties to mention the appeal for inclusion in the list for hearing as and when the same is ready for hearing. And if you file your application in the meantime, we'll direct it to.
So that's what
Yes, definitely. Just have it mentioned, we'll direct it to appeal. We'll take up the next matter after 5. Yes, Mr. Koth.
I have complied the order of your lordship. By which your lordship.
Mr. Chakravarti, please use the microphone. We can't hear.
I have complied the order of your lordship, my lord, by which your lordship my lord, directed me to serve the
Both the applications and memo. Yes.
a copy of
Mr. Poddar is appearing for the response.
No, my lord, your lord, my lord, I have made some allegation against the learned advocate, my lord, who was entrusted to file the appeal, my lord.
Oh, you have served a notice on him.
I have served notice. My lord, but that is
Good
not
service has been affected.
Yes. My lord, this is not a long delay. 100.
She is appearing.
No.
Yes, you have served. We can proceed. Yes.
My
What
lord,
is
107 days delay, my lord. I have stated.
what is the appeal against?
Appeal against eviction degree. My lord, I am in possession of the property, my lord.
But against a trespasser.
Oh, my lord. My lord, I have explained the delay, my lord, by stating the reason, my lord.
You are handed over the certified copy, but no appeal was preferred.
Yes.
Yes, Mr. Poddar, what do you say to the section 5?
I leave it up to your lordship, my lord. Since it is an eviction order against the trespasser, he is not the legal heirs.
That is on the merits. We'll
Yes.
first allow this and then we'll come to the stay application, then we'll hear. As per previous direction of the court, the appellant has served a notice of the present application on the erstwhile learned advocate for the appellants, against whom certain averments have been made in the application for condonation of delay. Full stop. Such receipt be kept on record. Full stop. However, the said learned advocate is not present at the time of call. Next para. The appellant has contended in the application that although certified copies of the impugned judgment and decree were handed over to his erstwhile learned advocate, no appeal was filed within time. Upon detection of the same, the current learned advocate was appointed and the appeal has been filed. Upon hearing learned counsel for the parties, we are satisfied that sufficient sufficient reasons have been made out for the delay in preferring the appeal. Accordingly, Can 2 of 2024 is allowed, thereby condoning the delay in preferring FAT 273 of 2024. There will be no order as to cost. The appeal is deemed to stand registered and admitted. Next pair. এবার একটা শুনে নিয়ে তারপর আবার অর্ডার দেবো Can 3 এর উপর Yes. What do you say, Mr. Poddar? Because against the degree of eviction of trespasser, he has preferred.
Yes, my lord,
Now,
come to page 6 of the impugned judgment, my lord.
page 6, yes. 2G.
See, my lord, he is not the legal heirs, my lord. But kindly see, said, my lord, second paragraph, said Pratap Kumar Mondal stated on oath that he is not the son of the plaintiff. And
He is the son.
Huh?
You said he is not the son. He is the son. Stated on oath that
Plaintiff. And Sitapati Devi Sonkar, Falwali, wife of late Nathulal Sonkar, was a monthly tenant under plaintiff in respect of one room on the ground floor at premises now 15 Nolini Shet Road, PS Posta, Kolkata 7 at a monthly rental of rupees 150 payable according to English calendar. Sitapati Sonkar had no issue and she died on 29 December 2012, leaving behind her no legal heirs and successors. He produced the counterpart of rent receipt which were issued in the name of Sitapati Devi Sonkar. He stated further on 29th May 2013, the learned advocate of the defendant informed plaintiff that Sitapati Devi Sonkar followingly died 29 December 2012 at Marwari Relief Society Hospital, Kolkata, and requested the plaintiff to change the transfer of tenancy in favor of the defendant. The witness tendered the death certificate of Sitapati Sonkar before the court. He stated that as the defendant is not legal heir, as per the provision of Hindu Succession Act, he has no right, title, interest in respect of the said tenancy of premises number 15 Nolini Shet Road,
PS Posta, Kolkata 7,07,000. He further stated that the status of the defendant is in fact of a trespasser as per provision of section 2G of Western Premises 1997 because he is not a legal heir of late Sitapati Devi Sonkar, as well as he is not a tenant in respect of the suit property. Here I used to mention 2G. But so, my lord, if he is not the legal heirs, if he was not living at the time of the living with Sitapati Devi during her lifetime in the tenancy, only after the death of the defendant Sitapati, this appellant through a learned advocate approached the plaintiff to accept him as a tenant. So, as per my lord, definition of tenancy, my lord, 2G, my lord, a person who was found residing with the tenant during his lifetime.
That's a mixed question. It has to be looked into. The evidence has to be looked into to find out whether he was
He
residing.
was not there, and he is not a legal heirs. And all these things that he was nurtured, he was, but it was mentioned in here. Thereafter, he was reared up by her, my lord. This is, but because only thing whether he was attached to the tenancy during the lifetime of the deceased tenant. That was discussed, my lord.
Whereas he admitted that he was not living with the tenant at the time of death. But has it been discussed in the
Yes,
judgment?
yes. No, no, I am starting from next section 2G Western Premises.
After that, after the italics.
Tenant means any person by whom or on whose account or behalf the rent or any premise of any premises or but for a special contract would be payable and includes any person continuing in possession after termination of his tenancy and in the event of death of any tenant also includes for a period not exceeding 5 years from the date of death of such tenant or from date of coming into force of this act, whichever is later, his spouse, son, daughter, parent, and widow of his predeceased son, who were ordinarily living with the tenant up to the date of death of the tenant as the member of his family, and were dependent on him, and who do not own or occupy any residential premises. And in respect of the premises later for non-resident purpose, his spouse, son, daughter, and parent who were ordinarily living with the tenant up to the date of his death as member.
No, where has he admitted? After the italics. After the italics portion, that is 2G quoted. After that, where you said he has admittedly he was not residing with the defendant at the time of her death. Where is that written? He was admittedly not residing with the original tenant?
Provided that the time limit for 5 years shall not apply.
You are reading the section.
Yes, yes.
Need not read the section.
Acha, acha.
You said he admittedly was not residing, came later. Not residing with this with Sitapati at the time of her
Yes,
demise.
yes. Kindly see, finding no other alternative, second paragraph.
Yes.
Of
Yes,
no
yes.
other alternative, plaintiff issued a letter dated 3rd May 2014 upon the defendant through her learned advocate calling upon him to vacate and deliver a peaceful vacant position of the suit property to the plaintiff within 1 month from the receipt of the notice dated 3rd May 2014. That the notice was sent under acknowledgement card and those documents were tendered by him before the court. He further stated the defendant received the notice and sent reply 10th June through his learned advocate. He produced that letter. It is prayer of the PW1 that defendant be declared trespasser with respect to the suit premises. During his cross-examination, he stated that the present defendant is not the tenant, not his tenant. The original tenant was Sitapati Sonkar Folwali. He further stated that long time back, Sitapati Sonkar was inducted as a tenant by his father, but he could not state the year or exact date when she was inducted as a tenant over the suit premises. He further stated during cross-examination, he filed the counterfoil rent receipt to show the tenancy of the Sitapati Devi Sonkar. He further stated that he heard that the husband of Sitapati Devi Sonkar died prior to the death of Sitapati Sonkar, but admitted that he has no document to show that the death of the husband Sitapati Devi Sonkar. After his advocate, the defendant never appeared in the court in order to complete the cross-examination of PW1 or to bring their own witness. As such, this court has no other alternative but
it was virtually an expert degree.
Yes, my lord. If they
it has been
reluctant to cross-examine.
Yes, but it has been held. It is decreed on contest. It's recorded in the ordinance.
Partially cross-examined, not completed. It is mentioned here. After this, an advocate of the defendant never appeared in the court.
Yes,
in order to
contest was not
complete
complete. When the decree was passed, they were not heard. No arguments were advanced by them.
in order to complete the cross-examination. It is
Yes, and the
cross-examination.
cross-examination from then on, he did not appear.
Yes, yes.
Therefore, when the decree was passed, it was ex parte.
I think from this sentence that defendant started cross-examination, but
Ye-
not completed.
Even then, if they appeared at some point of time and they did not appear after, no arguments were advanced by them, and then decree was passed, must have been recorded as ex parte. It's wrongly recorded as on contest. Anyway, what is your answer, Mr. Chakraborty? No prima facie case? You did not adduce evidence, did not complete their cross-examination.
Then whatever saying, my lord, kindly see, my lord, page 4 of the judgment, my lord, I have filed a written statement stating
Yes.
my specific case. Defendant has denied and controverted all the allegations leveled against him by the plaintiff. It is his specific case. Well, page 4, my lord, it is his specific case that he is the nephew of the late Sitapati Devi Sonkar, who was his aunt. He was reared up by the Sitapati Devi Sonkar. He looked after her during her lifetime, and when he died, he performed all the necessary rituals like sadhu, etc. He further mentioned that he paid rent on behalf of Sitapati Devi Sonkar. Since this is regularly after the death, the defendant started sending rents through money order, but the plaintiff refused to accept the same.
Sitapati died in the month of in the year December 2012.
My lord,
So in any event, they get advantage of 2G. Where is your prima facie case, Mr. Chakraborty?
Besides that, my lord, my prima facie case is that, my lord, I have stated in the application for stay that, my lord, during pendency of the suit, original plaintiff died. Original plaintiff died, and, my lord, one person, my lord, appeared with the file application stating that he has been appointed as an executor. My lord, that person has not been made a party. No probate has been, my lord, granted, my lord, by any court. My lord, and my lord, suo motu, my lord, the court, my lord, he has substituted the husband and the son as the legal heir. My lord, suo motu, my lord, and on basis of that, my lord, they have been allowed to continue the suit, my lord, without impleading the executor. And, my lord, and these are the, my lord, points, my lord, to be argued before your lordship, my lord, along with the entire evidence.
Respondent number 1 has died in the meantime, so respondent number 2 only. So they are the husband and son. So that in any event, if the will is not probated, not proved, then they by default they come in.
If the will has been made, executor is to prosecute the suit. Executor is someone else.
No,
not
Mr. Chakraborty, there is no case made out by them about the will.
My lord,
it's your case.
No, that is when the.
If they choose not to rely on that will and not take probate, then heirs have been brought in.
Suo motu, my lord, or suo motu, my lord, substituted the son and the.
Rightly so. If somebody dies, the heirs will be substituted.
I have taken the point, my lord. Kindly see.
Yes.
My lord, in stay application, I have stated, my lord, in paragraph that has not been controverted, my lord, that during, kindly see paragraph 4 of the stay application, that during, my lord, may I submit, my lord?
Yes,
during
yes.
pendency of the suit, the original plaintiff Ujjwala Mondal died on 9/9/2022. And after her death, an application was filed by one Ashish Kumar Samui.
Just making statements won't do, Mr. Chakraborty.
That is a record, my lord. Ashish Kumar Samui,
Yes.
who demanded that original plaintiff Ujjwala Mondal executed a will during her lifetime, and he has been appointed as an executor to the will left by Ujjwala Mondal. That in spite of proceeding the suit through executor appointed by Ujjwala Mondal, the learned court substituted Dr. Sunil Kumar Mondal and Pratap Kumar Mondal, being the husband and son of the deceased plaintiff, as the plaintiff of the suit. Well, when the will has been made, only executor can prosecute the suit. And, my lord, unless probate is granted, my lord, no final degree can be passed. My lord, these are the things to be argued, my lord. These are the things to be argued in the suit.
What happened to Ashish Kumar Samui's application? You have not stated that. He filed an application, you say?
Application, my lord, definitely, my lord, someone else has been substituted. That means that has not been considered, or my lord,
Yes, Mr. Poda, at this stage we won't shut him out. I will grant stay, but occupation charges you can disclose in your opposition.
My lord, what happened, my lord? Regarding will, my lord, he is saying, my lord, the person concerned who has been substituted by the learned court, he is no strange, nobody else but her husband and son. My lord, what my lord, wrong in it, my lord? It is not that the will was in the will, my lord. It was will was made in favor of the my
What
learned
happened to that
side.
application of Ashish Samui?
My lord, I don't know about the what happened. I have no instruction about that, my lord. But my lord, thing is this: if he is not the his client is not the legatee, or in other way beneficiary to that said will left by Ujjwala Mandal, he can't stand in the way. It is not the shoot on the ground of his own requirement. Even that own requirement, my lord,
We can direct you
ownership
to
would not
we
be proved.
can direct you to file paper books if you want. But for occupation charges, you file your opposition. We'll direct grant stay.
But since 2012, no payment, my lord. It is in the posta, in a commercial area.
You just disclose that. We will give you. How soon can you file your opposition? Disclose the location and something. How soon can you file your opposition? We'll do that.
Within fortnight.
The appellant argues that despite one Ashish Samui having applied for getting substituted in place of the original plaintiff on the strength of a purported will left by the said original plaintiff, the normal line of succession was followed and the heirs and legal representatives of the original plaintiff were substituted. Learned counsel for the respondent submits that since the heirs of the original plaintiff were substituted and the appellant does not claim to be a legatee of the will of the deceased original plaintiff, the appellant cannot have a say in the matter. Next para, that apart, it is submitted that the appellant is a rank trespasser. Next para, however, since the first appeal involves both questions of fact and law and an adjudication on merits, we are not inclined to refuse stay at this juncture, since unless an order of stay is granted, the appeal itself will be rendered infructuous before being heard on merits. Next para, however, we are not unmindful of the established legal position that for enjoying the premises, the appellant is required to deposit to pay occupation charges. Next para, accordingly, in order to enable the respondent to disclose the relevant factors in that regard and to controvert the averments of the application, the respondent is directed to file affidavit in opposition within a fortnight from date. Reply, if any, shall be filed within a week thereafter. The application shall be listed on February 12, 2025 for hearing. Next para, there shall be stay of operation of the impugned judgment and degree and or any execution case, if levied on the strength of the same in the meantime, till February 28, 2025 or until further order, whichever is earlier. Can 3 উপর এটা হলো. Thank you. Yes, please.
First of all, my lord, I am tendering unconditional apology because, my lord, there was a direction to, my lord, take out an affidavit in opposition, which I could not take out within time, but I have served it 7 days back to my learned friend.
Are you enjoying any interim order?
My lord, we are not, my lord. The order was passed on 17th of September 24, directing the parties to file affidavit in opposition by 2 weeks. Now, on the last occasion, on 14th of January, my lord, an adjournment was prayed for on the personal ground. We did not object, my lord. Our urgency was that before the learned trial court, my lord, the matter is returnable on 27th. Now, my lord, on Friday evening, my lord, we have received the affidavit in opposition. Because there are many documents annexed.
This opposition is by which of the respondents? Which bank?
My lord, by now, my
PSI Corporation.
PSI Corporation, my lord, banks have been made a party because my bank accounts were attached.
Oh.
My lord, pursuant to attachment, my lord.
What is the impugned order?
My lord, the impugned order is at page 174, my lord. My lord, I have challenged the condition imposed in the impugned order, my lord, where I have been asked to deposit 20% of the dues, my lord. Certain dues have been arrived at.
What is the suit for?
My lord, this is my lord an application under my lord 75(1)(g) of the Employee State Insurance Corporation Act, my lord.
I shall be, my lord, taking out subject to my lord what my learned friend would be apprising your lordship with regard to my lord the impunity that has been assailed before lordship. My preliminary objection, I do not my lord like to stand in this way. But preliminary objection, this is an interlocutory order, my lord. Appeal may not lie before your lordship. Because I'll be showing my lord the relevant provisions under which.
For the relevant provision, you reply to that first.
May I humbly, my lord, pray for a short extension of time to file my affidavit in reply, my lord, because certain documents have been given here. And my lord, may I pray for a small protection, my lord, limited protection till.
No, subject to.
My lord, then my lord will kindly take it up on next Monday itself. 27th January is the next date, my lord. We'll file a reply back. My lord, let it retain its position in the list. Kindly give us, my lord, 7 days.
Retention in the list position we can't guarantee, but applications are generally heard out in this court.
Because it's 27, my lord. We were hopeful that this appeal would be heard out before the returnable date. My lord, this is the last order passed, my lord. Other than a trial court, this was passed long time ago. If we go and pray for an adjournment, because it starts with that waiting for necessary orders passed by the honorable court. So, my lord, if so that way, that's why, my lord, that's the difficulty that we are presently in.
If you can file your reply by tomorrow, then we can keep it the day after tomorrow.
Can it be taken up on Friday, my lord?
Friday, no. Friday it sits singly.
Because Mr. Shomo Majumdar is leading in the matter, and today because of
professional. We'll keep it on 27 then.
I'm grateful.
You are filing your opposition today? File it. Affidavit in the opposition filed by the respondent ESI Corporation today be kept on record. Full stop. Since a copy of the same has been served on the appellants pretty recently, learned counsel for the appellant seeks an extension of time for filing the reply thereto. Accordingly, the time for filing reply is extended till January 27, 2025, when the application shall next be listed under the same heading. Come back on that date.
Well, the interim arrangement, my lord, let that continue, my lord, because the order says the injunction was extended till the next date.
We did not pass any order.
No,
Maintainability point has been taken.
We'll have to, before the learned.
Then I will hear the maintainability right now.
My lord, then we'll come back on 20.
Let us come back on that.
Well,
get
Character line add for the question of maintainability of the appeal is kept open for being urged at subsequent stages.
I'm get.
Great.
You also come prepared on that maintainability.
Yes, my lord, we'll.
Number 20.
Yes.
My lord, today they were supposed to give some supplementary affidavit and they were supposed to give some other documents in support of their condition.
By my instruction, my lord, he could not collect that document, my lord.
The affidavits are otherwise complete in there. So we'll hear out the stay application now, right now.
My lord, the stay petition, my lord, may be heard tomorrow morning. Tomorrow.
Why?
Because my lord, I have gathered few judgments, my lord, which is unprepared. It's not yet printed.
No, the appeal is against what?
It is a partition of a Devottor property.
So we are not hearing out the appeal at this stage. So we have made out a prima facie case, will extend the stay and direct you to prepare paper books.
Yes, my lord. But my lord, two judgments are there, my lord. I have collected from my lord B.K. Mukherjee's book, my lord, which is relevant at this stage, my lord. I want to show.
At the stage of granting stay?
No, my lord. Yes, my lord.
We are inclined to grant stay, extend the stay till disposal of the appeal.
It has
till disposal of the application itself. So disposal of the stay application, will direct a paper books to be filed quickly.
My lord.
We'll do that.
My lord.
Heard learned counsel for the parties, full stop. The present appeal arises out of you have challenged the preliminary decree of partition.
My lord, it is not written that it is preliminary decree. It is an order passed where the Devottor property has been partitioned. My lord, it is not even partitioned. My lord, it has been said. My lord, the Devottor property. My lord,
has been restrained from.
My lord, Devottor property is abolished because zamindari provision is abolished. My lord, and it is totally confused with Devottor property and zamindari property, my lord. Those two properties are taken together and said that since zamindari
my lord,
He filed a suit
provision
for
is-
earlier, he filed a suit for
my lord,
declaration, my lord, that was
my lord, there were
compromised.
many suits filed earlier, many writ petitions filed earlier, my lord. I am just pressing on this, my lord, this decree, my lord. Since zamindari property, my lord, zamindari provision is abolished, so my lord, Devottor provision is also abolished.
The present appeal arises against a decree whereby the defendants stroke appellants were restrained from disturbing the plaintiffs stroke respondents from offering and performing day-to-day Dev Seva. Full stop. Next para. Learned counsel for the appellants submits that the appellants have a strong prima facie case to go for the hearing of the appeal, comma, in view, comma, inter alia, comma, of there being a confusion in the impugned judgment regarding the purported abolition of Devottor rights created independently, comma, with the abolition of Zamindari rights. Full stop. Next para. Since a prima facie case for hearing of the appeal has been made out, comma, can 1 of 2024 is disposed of on contest, thereby extending the stay of operation of the impugned decree till disposal of the appeal. Full stop. The appellants, comma, however, comma, shall carry on maintaining accounts in respect of the property, which is the subject matter of the disputed Arponnama, as well as of the day-to-day affairs of Shiva Puja of the deities, and produce the same, comma, if directed to do so by the court at any point of time during pendency of the appeal.
Plaintiff and the defendants were directed to maintain that account.
No, now since they are getting the stay, they are direct.
I'll kindly see the order, my lord.
I've seen it.
Both of us.
We have seen it. You have stayed it. That's why. Next para. In view of appearance of the respondents through the learned advocates, you are appearing for all respondents. Yes, all are plaintiffs. Comma, service of notice of appeal on the respondents is dispensed with. Full stop. The trial court records be brought by special messenger at the cost of the appellants to be put in within a week from date. Full stop. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you. Next. Thank you.
I'm appearing on behalf of the opposite party. This is my affidavit in opposition.
The opposition was served pretty late. That is on Thursday. And this is the affidavit of service. Look up this.
Served the copy on the 10th.
10th is quite long back.
And subsequently, I have filed the affidavit in opposition, and I have served it on
When was served?
on 16th.
16th.
16th. So when do you want to file a reply?
My client is in Bangalore, so 2 weeks.
Tell us.
2 weeks.
Very well. The affidavit in opposition filed today be kept on record. Full stop. Learned counsel for the appellant seeks an extension for of time to file reply, comma, since a copy of the opposition was served only on January 16, 2025 on the respondents. Full stop. Accordingly, the time for filing reply is extended for a fortnight from date. The application shall next be listed on February 10, 2025. Thank you.
The item number 22, I appear for the appellant.
Lordship.
Yes.
My lord, Mr. Sukanta Chakraborty has instruction to appear on behalf of the.
Sukanta Chakraborty has instruction.
Yes, my lord.
No, tell him not to appear. If he has instruction, did you lodge a caveat?
No, my lord.
If the matter is pending before me, he should not take the matter.
One and respondent number 1 and 2. We did not yet receive the Vakalat Nama. That's why I'm praying for the release.
No,
of the
no, no.
matter.
We don't release on such grounds. Ask him not to appear for a respondent. Since the matter is already before me, before he,
But in
then we'll grant some time for the respondents to arrange. No, respondent numbers 1 and 2. You are for 3 to 5. 1 to 2 has to be given opportunity. An adjournment is no, it is submitted. What is your name, please?
Romodip Shaha.
Pardon?
Romodip Shaha.
Mr. Romodip Shaha, learned advocate, submits that since one of my relatives has instruction to appear on behalf of the respondent numbers 1 and 2, the court may consider as to whether the matter should be released on such ground. However, since the matter is already appearing before this court and the said person has not yet entered appearance on behalf of the respondent numbers 1 and 2, I do not find any reason to release the matter. It is for the said learned advocate to, it is for the respondent numbers 1 and 2 to consider choosing some other learned advocate to represent them in the appeal and the application. Accordingly, to grant some time to the respondent numbers 1 and 2 to engage counsel, let the matter stand adjourned till February 5, 2025. We give you 1 week's time. Ask Mr. Chakraborty or you not to appear in the matter yourself. Ask your clients to engage somebody else whom you will not suggest. Yes. তাহলে যে ম্যাটার এখন অ্যাপিয়ার করে ও সেটা করছে না তাও justice must also appear to be done. Yes.
Look, I am for the petitioner, appellant.
They were to file some supplementary affidavit.
Yes, my lord, we have already filed and copy has been served, my lord.
Oh no, they have to come ready on this. What is the application for condonation of delay?
Yes, my lord. 19 days delay, my lord. At that period, my lord, he was.
What is the supplementary affidavit about?
Initially, there was no ground for delay. Your lordship granted an opportunity to file a supplementary affidavit.
Where is the supplementary? First, let us find it out. You have filed the supplementary affidavit. Let us just find out. Yes. What is the explanation?
He was suffering from several hyperacidic,
high blood pressure.
Yes, my lord. And I have and
19 day. Something has been shown.
Acidity and hepatic disorder.
Pardon?
Acidity and hepatic disorder.
No, page 4, paragraph 4.
Acidities.
And high blood pressure.
High blood.
As your lordship knows. Respect of notion of delay.
You should make out a good story at least. Acidity and hepatic disorder.
He was,
were you hospitalized?
Yes, he was under treatment, my lord.
Under treatment? All of us are probably suffering from acidity when we hear matters. Or argue matters.
Liver problem.
Bad judge, bad lawyer.
No,
acidity creates acidity in the other.
Liver problem, my lord. Chronic
liver problem has not been stated. Anyway, 19 days.
Annexure 5, my lord, not signed by the doctor, probably my copy. Certificate.
Yes.
There is no annexure 5.
Annexure A1, page 5, my lord.
Achha.
This is the
not annexed to your copy. Why are you doing it such as?
No, annexed, my lord, but it's become illegible due to photocopy. Signature of the.
Anyway, heard learned counsel for the parties who taking into consideration the amendments made in the supplementary affidavit to the condonation application, we are satisfied that sufficient grounds for the delay of about 19 days have been made out in the application. Accordingly, can 1 of 2024 is allowed on contest, thereby condoning the delay in preferring FMAT 365 of 2024. There will be no orders to cost. What is the appeal against?
Well, appeal is that it is a partition.
So we are treating to be with consent of both parties. We are treating to the appeal to be under order for Rule 11. So we are taking up the appeal because we have determination now. Yes. What is the appeal? Move it. Is there any defect? There are certain defects pointed out.
We have
removed.
Yes.
Instant appeal is preferred against. সেটা করেনি এখনো হ্যাঁ করেছে এফএমটি নাম্বার হয়ে না এফএমটি নাম্বার পড়তে হয়েছে এফএমটি এফএটি the appeal is against what?
Original degree, my lord, primary degree.
Then defect has not been cured. One of the defects was that preferred with court fees of rupees 100.
Yes, my lord.
So there is no order for Rule 11 hearing required if it's a first appeal. Court fee of 90 rupees deficit court fee.
Yes, my lord. We have.
When did you put in?
My lord, we have filed.
There is no. Achha, let us check up. No, they still persist.
No, my lord. We have filed in the
Deficit court fee has been put in.
Yes,
What about the other defects?
my lord.
The memo. Only other defect is you have to classify it properly, the memorandum.
We have
You have done it?
Yes, my lord.
Just a second. এখানে কিন্তু করে দিয়েছে বাই লিভ অফ করে তো করে দিয়েছে হ্যাঁ ওরা করে দিয়েছে এটা রিক্লাসিফাই করেনি অফিসকে করতে হবে সেটা কিন্তু অফিস ইজ টু ক্লাসিফাই দিস অ্যাজ অ্যান অ্যাপিল otherwise we can't pass we'll direct the office to do it immediately and put it before us after a week. We find that the appellant has already carried out the necessary corrections and put in the deficit court fees for preferring the appeal. The memorandum of appeal has also been corrected by depicting the appeal to be from an original decree. Accordingly, the office is directed to reclassify the appeal as of regular first appeal and allot an FAT number thereto within a week from date. Next para. The file be sent down immediately to the office for such purpose. The matter, what other application is pending? Can 2.
Injunction application is pending, my lord.
That is can 2 or can, yes. Can 2 of 2024 shall be listed for hearing on February 11, 2025. A revised report, আচ্ছা না দরকার নেই রিভাইজ রিক্লাসিফাইটা করে এটা অফিসকে পাঠিয়ে দেবেন অফিসকে একটু বলে দেবেন যে এটা যেন রিনাম্বারিংটা করে আবার পাঠিয়ে দেয় ফাইল আপনাকে
Can 2 is a condonation of delay. Can 1 টা উঠবে মনে হচ্ছে আপনার can 2 তো condonation of delay. Can 2 is a condonation of delay.
No, can 1 is the content in the original. Probably wrong number has been written in your 500 ম্যাটার both side থাকলে ডাকবে সে বলেছে কিছু both side 500 ম্যাটারটা একবার দেখে দিন তো তাই নোট করে দিন not to record them. At order record in the second call, none appears. Let the matter stand adjourned for the day.
My lord, I appear for the appellant.
Yes.
My lords, on 5th, can 1 is an injunction application. On 5th of December, my lords was pleased to pass an order granting us the injunction, which was duly served as per the rules, lordship, on the very same day. After your service is there, we haven't received any opposition thereafter, or I do not think they have still entered up.
Good service has been effected.
Lordship, good service has been effected.
Only one respondent.
Only one.
So, what is the nature of this appeal?
Lordship, this is we have pleaded that there was an oral. Lordship will kindly see Lordship's own order. Lordship has actually recorded in a very crisp manner. Paragraph 2. This is the sum and substance of our claim, my lords. I am a tenant in occupation of a shop room. The landlords had taken extra money from us, if I may put it, my lords. An oral agreement was entered into, which is pleaded in paragraph 11, page 6 of our application. That is the oral agreement that we had entered into. Thereafter, they have neither repaid and they've also stopped issuing any notices, any rent receipts.
She'll extend the injunction till.
The injunction is there. If the Lordship's order.
Not till disposal of the appeal now, and we'll prepare paperbooks quickly.
Lordship will kindly allow.
None appears despite service on behalf of the respondent. The affidavit of service filed to be kept on record. Stop can 1 of 2024 is allowed, comma, thereby. No, sorry, last sentence. In the order dated December 5, 2024, comma, elaborate reasons were recorded for grant of ad interim injunction. Next para, we do not find any change of circumstances in between, comma, nor does the respondent appear or point out to us any such change. Accordingly, we find that the interim order granted earlier ought to be extended till disposal of the appeal. Accordingly, can 1 of 2024 is allowed, thereby restraining the respondent and or its men and agents by an order of injunction from disturbing the peaceful possession of the plaintiff / appellant and / or from transferring and or creating third-party interest in respect of the suit property in any manner whatsoever, comma, except without due process of law till disposal of the appeal. Full stop. The trial court records are required.
Lordship, it's only the plaintiff and it's
Full stop. Next para.
adding to
Next para. In view of the brief conspectus of the appeal, comma, trial court records are dispensed with for the present. Which of the appellant shall prepare and file the requisite number of informal paper books without comparing with the records, annexing all necessary documents within 6 weeks from date. Full stop. Liberty to the parties to mention the matter as and when the same is ready as regards service.
I'm so grateful.
My lord, item number 15, Lordship passed it over, and
Yes.
made it not today, but only requesting kindly keeps it on Wednesday because I'm in some difficulty tomorrow, personal difficulty.
But we have passed an order when if it is called on tomorrow, ask somebody to ask for time. Just remind us.
Okay.
Yes, next.
Lordship, I'm appearing on behalf of the respondent number 1.
What about the affidavit of service?
Lordship, I have received the brief today itself.
You had to file an affidavit of service today.
Instruction to file affidavit. There was an instruction.
9th January order records appellant shall serve copies of both the applications on plaintiff number 1, respondent number 1, indicating and an affidavit of service to that effect shall be filed today.
I will make it.
Learned counsel for both sides seek adjournment. Full stop. Let the matter stand adjourned for the day. Thanks.
Number 23. I'm for the respondent. I'm for the. Opposition one is time.
You are enjoying an injunction or whatever interim.
Well, affidavit of service.
Till disposal of the application. Very good. Affidavit of service filed today be kept on record. You are for which respondent?
Respondent number 1.
Who has not been served, Mr.
Pro forma respondent.
You are not
Non-active
seeking relief
liability.
against relief.
No.
The affidavit of service filed today be kept on record. Full stop. It transpires that although the pro forma respondent has not been served, comma, both the principal respondents have been served. Full stop. Since no relief has been sought as such against the pro forma respondent, comma, service of a notice of the application on the said respondent is dispensed with. Full stop. Learned counsel for the respondent number 1 seeks in opposition to the application. Full stop. Next para. How soon?
2 weeks, madam.
Accordingly, the respondents are directed to file affidavits in opposition to the application within a fortnight from date. Replies, if any, shall be filed within a week thereafter. The application shall be listed for hearing on February 19, 2025.
It's an appeal against an interim order.
Can dispose of the appeal.
Dispose of, remand it back to the lower.
Come prepared on the appeal itself, will dispose it of.
Because again, opposition there, again.
Yes, why are you using an opposition? We could record that you are not anyway. What?
Same rigor will continue.
Yes, Mr. Chatterjee, what is the matter?
I am the appellant.
Yes.
My lord, initially, my lord admitted the appeal with an interim order. My lord, stay of the operation of the judgment. My lord, we have served.
The judgment is to the effect, I mean.
My lord, to the, I tell your lordship, my lord.
This is a custody matter?
Yes. My lord, the custody matter where, my lord, the learned trial judge held, my lord, the child is abandoned child and referred to, my lord, CWC. And
oh, you are the
yes, my lord,
adoptive.
Yes, my lord.
We passed an order of stay of operation. The good service has been effected.
My lord, yes, my lord. I tell your lordship very frankly, my lord, the opposite party is the grandmother. Now, my lord, grandmother, my lord, has consented. My lord, Mr. Rai Parthopratim Rai is appearing for the grandmother. I have spoken to him also.
Yes.
My lord, he will support my case. My lord, he has consented before the court below.
But ask him to put it in writing.
My lord, before this court, my lord.
Before this court, will keep it on record and dispose of everything.
Very well.
She is the legal guardian.
She is the, my lord, legal guardian as the mother is.
Surrendered child?
No, not surrendered the child because, my lord, I tell your lordship, my lord, after the child is in my custody, my lord. Or, my lord, I am in guardian, my lord, of the child. Now, my lord, after the order was passed, my lord, stayed the operation. The child remains with me. And, my lord, the mother, the grandmother, my lord, is still consenting. My lord, the child be with me. So, my lord, in that event, my lord, the only.
So, everybody is consenting, but the procedure was not under the Juvenile Justice Act. That is the difficulty.
My lord,
consent cannot legalize it, Mr.
Lord,
we can pass an illegal order for equity, but we
not known. My lord, the mother is, my lord, of unsound mind and missing.
Oh, she was found on the footpath with the child.
Yes.
Grandmother, where is the mother? The biological mother, she's of unsound mind.
She's
She's
of
under
unsound mind.
treatment.
She is missing. My lord, a general diary is lodged in the police station. My lord, after discharge from the hospital, the mother was sent to the parental maternal home. So, my lord, from there she went again missing. So, my lord, a GD has been lodged to that extent. And my lord, certificate from Pavlov has been issued. She is suffering from schizophrenia and my lord, mentally not sound.
As pathetic as can be. He served personally.
My lord, yes. Because actually, my lord,
he served a registered post. This will create some doubts in future. Personal service, as if it's collusive, LTI.
My lord,
he also lives on the footpath.
No, she has a house.
Then,
but since Mr. Rai is actually consenting, a grandmother is consenting, my lord, even if it is
but
found
you
that we are
served
in
on the party, you should have served by registered post. He could have appeared in the meantime. But this is not proper service. Serve it at the address.
Very good. I shall serve.
Affidavit of service filed today be kept on record. You are already enjoying till disposal of the application.
Yes. Yes. Till disposal of the present application.
Affidavit of service filed today be kept on record. First up, we find that personal service has been purportedly affected on the respondent, comma, who is allegedly the biological maternal grandmother of the child in question. First up, however, comma, we find that the respondent received the service apparently by putting her left thumb impression. Push up, since it is not possible for us to ascertain the veracity of such left thumb impression, push up, comma, the petitioner is appellant stroke petitioner is directed to serve the respondent by registered post with AD instead of personal service. Push up, a fresh affidavit of service to that effect shall be filed on the next returnable date. The matter shall next be listed on February 17, 2025. When such fresh affidavit of service shall be filed. Push up, next para. This much, the interim order is already. So as delayed as possible, it will help you. We have another bench. We'll sit again at 2. I have another bench with Justice Bishas, Jalpaiguri matter. So that's why it's not in the list. We'll resume this bench. Will resume at 2. Bodeshok. You are for the petitioner?
I am the petitioner.
This is a contempt application?
Yes.
What is the nature of contempt? Appearing for the first time?
Yes.
This is appearing before us. What is the nature of the contempt? What is the order?
Actually, it was pension matter.
Right.
He's the senior citizen. The
Yes.
order, the superintendent police of Jalpaiguri.
You are to get pension.
Yes.
On the demise of your husband.
Yes.
Who worked with the police.
Yes.
So pension has not been given to you.
No.
Have you furnished the documents? You are directed to furnish some documents for getting that pension. Where have you alleged that you have furnished those? Because if you see the order, paragraph 12 of our order, the order under contempt. Which is the order under contempt? The order dated?
Order dated, my lord, 13 January
Oh,
2025.
13 January. 13 January,
No, no,
30th
no,
of
no,
July.
13th of July.
30th of July.
Yes, yes.
30th of July.
Yes, sir.
We are directed, please come to para 12 of the order.
Yes.
In such view of the matter, such and such is disposed of without interfering with the impugned order, but directing you, the petitioner, to furnish the documents as enumerated in item numbers 3, 4, 5, and 6 of the communication by the SP before the respondent authority at the earliest. Upon furnishing, they will do it. So where have you averred in your application for contempt that you have furnished those documents?
Yes, my lord.
Show us that paragraph of your application that you have done it.
Please fix up a next date, short date.
How will you help if it is not in your averments? We don't find any averment on that. Let us see whether you have. No, you have not. We will permit you to use a supplementary affidavit to put in that averment.
Okay.
Learned counsel, learned counsel for the petitioner submits that in violation of the order dated July 30, 2024, passed by this court, the alleged contemner has not disbursed the pension of the petitioner. Whose of next para, we find from paragraph number 12 of the said parent order that the petitioner was directed to furnish the documents as enumerated in item numbers 3, 4, 5, and 6 of a communication dated July 5, 2021, made by the Superintendent of Police, Jalpaiguri, annexed at page 44 of the original writ petition, original application, before the respondent authorities at the earliest. Only upon furnishing of such documents, the liability of the respondent authorities was to arise to ensure that the share of the petitioner in pensionary benefits on the demise of her late husband were disbursed in her favor. Next para, however, we do not find any averment in the application insofar as the petitioner having complied with her part of the said direction by furnishing the necessary documents in terms of paragraph number 12 of the parent order. On the prayer of the learned advocate for the petitioner, the petitioner is granted leave to file a supplementary affidavit incorporating necessary averments and photocopies of documents to show that the petitioner has furnished the documents as per the direction incorporated in the order under contempt. We shall keep it how when should we, 2 weeks after?
Yes.
Very well. The application shall next be listed on February. We'll keep it on February 17th. February 17, 2025. Oh, acha.
Circuit bench.
Circuit bench. My learned brother at that point of time. তাহলে আপনি যেটা বললাম থাকবে লাস্ট সেন্টেন্সে কেটে দাও অন দ্য নেক্সট রিটার্নেবল ডেট বলেছে কি না তার আগে সাপ্লিমেন্টারি এফিডেভিট কবে ফাইল করতে বলেছে shall file a supplementary affidavit leave is granted বলেছি আগে সেন্টেন্সটা শেষ হচ্ছে কি দিয়ে
to file a supplementary affidavit incorporating the necessary averments and photocopies of documents to show that the petitioner has furnished the documents as per the direction incorporated in the order under contempt.
On the next returnable date. Full stop.
My lord, March first week.
No, the difficulty is my learned brother is sitting in another division bench, so we have to take leave of from that the other partner from that bench. So we'll put in, we'll say that we'll notify the next date previously. Since this bench is not a regular bench, the returnable date of the contempt application shall be notified in the list in advance. We'll notify in advance. দেখেন ওদের তো ফোর্টনাইট টাইম আমাদের নেক্সট রিটার্নেবল ডেট বুঝছো অন্তত 2 সপ্তাহ টাইম দিতে হবে তাহলে আপনি ফিরে আসছেন যাবে আপনি একটু আগে থেকে জাস্ট স্যামিনের সঙ্গে কথা বলেন আমরা লিস্ট
Lord, may I be permitted to mention one?
No mentioning now. Follow
Follow.
this. Follow the list.
Item number 28.
Lord, I beg to appear for the plaintiff appellant.
Yes.
Lord, pursuant to his lordship's direction, my lord, service has been effected. No, in sender. Back to sender. Acta service.
Has been affected.
Lord, to one, my lord, I find it has been affected. The first respondent.
Yes.
Lord, with respect to the others.
Your prayer is against the
Second one is also delivered.
1 and 2. Your relief is against 1 and 2.
Yes,
Or
my lord, the
performance.
remaining are, my lord, the pro forma. So, my
Correct.
lord,
File that affidavit of service.
Lord, may I file the affidavit?
Yes.
Lord, Mr. Banerjee, my lord, was reading. Why not?
Mr. Banerjee.
No, Mr. Siddhartha Banerjee was leading me, my lord.
So he is sitting.
Let's start.
So they are not appearing. We'll extend the interim order till disposal of the appeal. Affidavit of service filed today be kept on record. Push up. We find from the same that the primary contesting defendant numbers 1 and 2, who are respondent numbers 1 and 2 herein, have been served. Push up, since no relief has been claimed against the pro forma defendants to pro forma respondents, further service is not directed on the said pro forma respondents. So next para, in the order dated December 4, 2024, we had recorded that from the impugned order in the appeal, it is evident that the same is absolutely devoid of reason. Upon consideration of the materials, we had directed ad interim injunction to be, we had passed an order of ad interim injunction. Next para, since we do not find anything on record to show that the circumstances have, since, altered, we are of the opinion that the ad interim order should be made absolute. Accordingly, can 1 of 2024 is allowed, thereby restraining the respondent numbers 1 and 2 and or their men and agents by an order of injunction from selling, transferring, encumbering, and or alienating the suit property in any manner, from changing the nature and character of the suit property, and or dealing with the suit property in favor of third parties in any manner whatsoever till disposal of the appeal. Next para. In view of the, we are not directing trial court records to be brought, injunction. In view of the brief conspectus of the appeal, the trial court records need not be called for at the present juncture. Which of the appellants shall prepare and file the requisite number of paper books. The appellants shall put in requisites for service of notice of the appeal on the respondent numbers 1 and 2, which of service on the pro forma respondents is dispensed with. The appellant shall file a requisite number of informal paper books without comparing with the records within 6 weeks from date, incorporating all necessary documents. Liberty to the parties to mention for inclusion as and when the appeal is ready as regards service.
Lord, I am for the plaintiff appellant.
Yes.
Pursuant to my lord's slight direction, my lord, I have served, my lord. It was served on 23rd of December 2024. There was a direction to file affidavits by 10th of January 2025. No affidavits.
You served only on defendant number 1.
All respondents. There was a direction to serve upon all the respondents.
You have served all.
All.
Yes.
Pay for 1 week's.
You are appearing for whom?
Yes, Bank, your lordship. Respondent number 1.
Why? It was directed long back to the for.
We have been recently appointed in this matter. We have asked for specific instructions.
You are enjoying an interim order till disposal of the application.
Till disposal of the application.
Very well. On the prayer of the respondent number 1 stroke Yes Bank, the time for filing opposition, affidavit in opposition is extended for a week. For a week from date. Reply, if any, shall be filed within a week thereafter. The application shall be listed for hearing on February 10, 2025.
Great.
Number 30.
For the appellate.
Respondent number 1, your lordship. The last
Necessary corrections has been done, my lord.
It is, my lord, instead of order, that should be degree. That has been carried out, my lord. And in last occasion, my lord.
What is the application for? Can 4?
That is not my application. That is.
Oh, sorry. This is not, the application is not appearing. This is for Logimo. So you have carried out the correction.
Yes, yes.
And has duly cured the defect. Very well.
Wrongly, it has been recorded.
Very well.
Order. That
So
is-
then you get absolved of the defect.
Yes,
Now you are the appellant.
Yes.
So directions for paper books were filed.
Yes,
Formal paperwork have been filed.
everything
Have been filed.
Yes, madam.
The appeal will be listed, but we cannot direct it to be listed immediately. We'll direct it to be listed in the monthly list of March.
Not if some precedence could be given.
No, cannot right now. The report of the assistant registrar within bracket SR section bracket closed dated January 17, 2025 indicates that the defects have been cured by the appellant in the meantime. Full stop. Accordingly, the appeal is treated to be informed. Full stop. Next parallel, counsel for the parties submit that the appeal is otherwise ready for hearing and paper books have already been filed. Full stop. Accordingly, let the appeal be listed for hearing in the monthly list of March 2025.
Lordship, then can 4 be disposed of?
What is can 4?
Can 4 is to why the show cause the lower court records have not
Lower court records have arrived already.
Yes, lower court records arrived for it.
তাই তো report তাই ভাবে।
No, reports do not say lower court records have arrived.
Then that can.
Paper books were directed to file to be filed after arrival of the trial court records.
There was some in the year 2022.
No, let us see whether they. No, records have not yet. When was the paper books? When were the paper books directed to be filed?
In the month of July.
19th of July 2021, the direction was given by.
Within the time, I filed the paper books. Along with the requisite for special messenger to call for the record. That has been filed. That has been deposited in due time. Within the time. In the month of July 2021.
No special. No.
Lower court records perhaps have not arrived, your lordship.
No, trial court records were not dispensed with. আচ্ছা এর আগে সেন্টেন্সে কি বললাম যে since learned counsel for the parties submit last sentence যেখানে বললাম since learned counsel for the parties submit that the appeal is ready for hearing এটা এই সেন্টেন্সে কেটে দাও সেন্টেন্সে কেটে দিয়ে নতুন করে করো learned counsel for the parties submit that paper books have duly been filed pursuant to the order dated July 19, 2021. Push up. Accordingly, the office is directed to furnish a report as to whether the trial court records have arrived, been examined and found to be complete. Push up. Such report shall be tagged with the main file and be placed before the court on the returnable date. Push up. The appeal be listed on February 10, 2025 under the heading to be mentioned for passing further orders. এটা ডিপার্টমেন্টে পাঠাতে হবে রিপোর্টের জন্য
Number 31, my lord, I appear for the appellate.
Yes.
But on the earlier occasion, restoration application along with section 5 has been allowed by your lordship.
Right.
Now, my lord, I am challenging the decree passed by the learned court on 27th of December.
Decree?
Judgment and decree.
Why misappeal?
Well,
it is classified as a misappeal.
Decree has been passed. But I am telling your lordship. Matrimonial suit. I was the.
How could it be classified as a misappeal? Let us see your memo. Why FMA? You have filed it properly. It's a demand order or something. No, we said decree expert. Yes, regular degree. Office ki kore. Yes, there's a report also. No, it has to be classified properly. It is not required to be admitted. No admission hearing is necessary. The present appeal has been preferred against an ex parte decree of divorce. Full stop, next para. As per the report of the additional stamp reporter dated September 18, 2017, comma, the learned advocate for the appellant may be required to rectify the classification of the appeal so as to enable the office to categorize it as a regular first appeal. Full stop. However, comma, we find from the memorandum of appeal that the same carries no mistake, comma, as it has been properly captioned as a memorandum of appeal from original decree. Full stop. Next para. Accordingly, such report to that extent be ignored. Full stop. The office shall immediately take steps for classifying the present appeal as a regular first appeal and allot an FAT number thereto. Full stop. Such exercise shall be carried out by the office within a fortnight from date. Full stop. There is no connected application.
One application, expeditious disposal.
That's very well. The said correction shall be within a fortnight. Within a fortnight from date. Full stop. The connected application be listed next on February 12, 2025. এটা অফিসকে বলে দিই। We intended to give them an opportunity of hearing at the admission stage. You have served notice?
Yes,
Good service.
So far as regards the answering respondent 1, 2, and 3, it's received. The track report of 4 and 5, though it's not so German, but the track report suggests that that is the Association of Physician West Bengal Circle is the answering respondent. Because I have shown before your lordship that the organizing secretary and organizing president that has been suggested by the West Bengal Circle, ratified by the central body, that is API. And that after that ratification, they are not in derogation of that arrangement now going to appoint, rather going to appoint someone else as an organizing secretary in respect of the EPICON, the conference which will be held on 24th to 26th of this month, 23rd to 26th of this month. And another query of your lordship, that whether I have put in the requisite before the learned court below, because the ad interim prayer was rejected. So requisite were put in and they have appeared before the learned trial. Right. But those order are with you. May I just show before your lordship?
Yes.
Yes. The plaint, rather not going to the plaint, if your lordship takes up straight away, page 48 is the constitution of the Association of Physicians of India. This is for West Bengal branch. I have shown before your lordship page 57, it's continuation of that constitution, rule 17. Rule 17 suggests that API West Bengal branch from time to time may get the responsibility to organize EPICON, annual conference of API. Under such situation, the names of organizing secretary and organizing chairman and organizing committee has to be proposed by EC committee of API West Bengal branch. It is also to be confirmed by the general body meeting of API West Bengal branch. Finance related to EPICON shall not be accounted under the name. It's not important for our consideration. If your lordship takes up the next page, page 58, for the purpose of constituting this EPICON was scheduled to be happened on 2024, but due to COVID, my lord, this has been, my lord, postponed, and it is now going to happen in 2025, 23rd to 26th January. My lord, it's a meeting held on 2020, where, my lord, the agenda is, this is to inform you that the meeting of API governing body of API will be held on Sunday, 5th January 2020 at the Hotel Joypai Palace of Convention Center, Faridabad Road, such and such. Agenda for breeding Epicon 2024 will discuss. You are requested to present such and such. Now, my lord, if your lordship.
No, this is dated 16th February 2024.
My lord, yes.
But it says that will be held on 5th January 2020.
No, my lord, it's 23rd of, my lord, the mail date is, my lord, nearing date Monday,
Oh,
23rd December 2019.
This is the printout date.
Printout, my lord.
All right, very well, yes.
My lord, next, my lord, your lordship will get, my lord, page 66 of my lord's brief. That was discussed, and
yes,
this is to certify that as per the decision of the 75th annual general body meeting held on 6th January, now, my lord, your lordship will get 2020, held at Agra, considered the application received from API West Bengal chapter for the venue of Epicon 2024 at Kolkata, West Bengal chapter. The organizing chairman will Dr. such and such, and the organizing secretary, my lord, the name of the appellant.
Yes.
Now, the injunction application, I have read the, my lord, page 86, prayer B.
Yes.
This is 20. I have read this letter, my lord, purported resolution of 21st of September 2023 should not be given effect to. Why, my lord? Because the, if your lordship takes up page 112,
yes,
gives the cause of action for filing of my suit. This is a, my lord, communication of the secretary of the West Bengal chapter, that in response to your letter regarding the organizing secretary of Epicon 2025 to be held on Kolkata, our observation follows. As per Epicon norms, headquarter API is supposed to send a letter to the state chapter asking the name organizing secretary, which will be adopted by the governing body meeting on 24th February at New Delhi during Epicon 2024. So they are resigning from their own decision, which was ratified by API West Bengal chapter will decide the name of organizing secretary in its EC meeting, which will be held only after receiving letter from headquarter about the same. Therefore, the declaration of the name of the organizing secretary does not arise now. Further, you may send document as attachment why you are saying to declare you now as organizing secretary.
What is page 139?
Yes, 139, my lord, is another communication.
To whose advocate?
My lord, to my advocate.
Yes.
My lord,
by whom? The secretary?
Yes. That API West Bengal, third paragraph, as your lordship got it.
Yes.
That API West Bengal had its executive committee meeting on 21st September 2023, which was attended by your client and unequivocally concluded, later mentioning that the approval of your client as organizing secretary has not been approved by the executive committee prior to or after 5th January. That your client ought to have apprised you all about the happenings taking place in the executive committee meeting on 21st September 2023, as also the special general body meeting of API West Bengal chapter held on 20th October 2023. This, my lord, gives a cause of action. They are resigning from their own decision.
West Bengal chapter was to, who was to, the central API was to...
the central API has given ratification of whatever the decision that has been held on 5th of January 2020 by the West Bengal chapter.
Have you got a copy of the 6th January 2020 West Bengal chapter meeting? Page 66, you have annexed the ratification.
Yes, my lord.
That is not there.
That is not there.
But that mentions it.
That mentioned, that's why, my lord, they have mentioned the 75th annual general meeting at page 66.
Show us something to indicate that this was postponed to, that now the present conference is this conference which is being...
Lord, that is there, my lord, in their letter itself. My lord, I have shown before your lordship. First notice, page 112. That is one of the communication on 28th of June 2023. At the
Yes.
top, your lordship, in response to your letter regarding organizing secretary of EPICON 2025.
Yes, but agenda for bidding EPICON 2024 was to be discussed at page 58.
Milord, here also it has been mentioned, as per EPICON norms, may I place before your
Yes,
lordship?
yes.
Headquarter API is supposed to send a letter to the state chapter asking the name of organizing secretary, which will be adopted in the governing body meeting of 24th February at New Delhi during EPICON 2024. So, Milord, this EPICON 2024 was scheduled to be happen, for which 2020 itself the committee was being constituted, ratified.
All right.
This has been postponed. Now it's going to happen in 2025.
So how do you
there-
find that 2024 there was nothing? There was no conference. So after 2024, you have shown us that it was postponed.
It was the API West
I mean,
Bengal
page 58 says this choice is for the purpose of 2024.
2024.
Now, page 112 says yes. Again, reiterates meeting on 24th Feb at New Delhi during EPICON 2024. So,
This
it was to be
this was
EPICON.
scheduled. This was scheduled, Milord, in 2024 itself.
Where do we get that? That was it is that meeting which was postponed to this 2025. Because it may very well be the other side may argue that that meeting was held in 2024 and you were the organizing secretary there. And this is a fresh thing. We get nothing on record to show that that was postponed to this date. All at executive meeting was held on 2020. Page 139 mentions 2023.
2023.
But 2023 was also very well. They refer back to this. At page 139, they refer to that.
Because 2024, Milord, there was no meeting held, no conference held.
How do we get that? I mean, something must be on record. Because the last thing we get is page 139.
139 also.
That is also dated 2023.
That is a communication, Milord, which is the cause of action of my suit.
But all of this is for 2024 meeting. It refers to 21st September 2023 and 21st September 2023. Where do we get that? That is not there.
No, that is not there. That has not been communicated.
They say that they had a meeting.
Yes.
They say it was attended by you. And
But your lordship kindly once takes up.
They say equivocally concluded, but it should be unequivocally.
If your lordship takes up page 131 once.
Yes.
There your lordship will get, Milord, this thing is being mentioned. Page 131, second paragraph. That my client was, has your lordship got?
Yes.
My client was selected as organizing secretary by the decision of 75th
This is your
Annual
letter.
General Meeting.
Your letter.
Yes. Meeting held on 6 January 2020 for the venue of EPICON 2024 at Kolkata, West Bengal chapter. Due to the COVID-19 pandemic situation, this conference is, will be held in Kolkata on 2025. Now your lordship will get, Milord, that email communication. As per the letter through email on such and such, the Honorary Secretary API West Bengal chapter, my client came to know that his name will be eliminated and the new name will be adopted in the governing body meeting 24th February at New Delhi during EPICON 2024. After that, an emergency general, because in every year, Milord, there was an EPICON. But in 2024, it was scheduled to happen in Kolkata, which was rescheduled. It is going to happen in Kolkata in 2025. And in 2024, it was held on Delhi. That they have also, Milord, mentioned. 2024 EPICON was held in Delhi. That is, your lordship will get at page 139. This will synchronize these two.
Where is that stated?
Yes, Milord, if your lordship takes up, Milord, this
139.
No, Milord, not 139. I'm sorry, Milord. This previous communication. That is at page 112.
Oh, during EPICON 2020.
Yes.
No.
Governing body meeting on 24th February at New Delhi during EPICON 2024. So
no,
this
that is dated 28th of June 2023. When they say that that 24th the general body meeting will be held
on
EPICON
during EPICON 2024 at Delhi. So 2024 EPICON was held in at Delhi. Not
no, we don't get that it was held. 2023, in 2023, it states that as per Epicon norm is supposed to send a letter to the state chapter asking name of organizing secretary.
Yes.
Which will be adopted in
Adopted
governing
the
body
governing
meeting
body meeting on
during Epicon 2024.
Yes. At Milord, that is.
So that means it will be held in 2024.
But in Delhi, if it is going to held in Delhi, Milord, there is no question of giving effect of West Bengal chapter for selection of anything. Because if the West Bengal chapter is going to held Epicon at West Bengal in 2025, my Milord constitution is for the West Bengal chapter only. Milord, in every year, it used to happen in different states. So in 2020, whatever has been decided for West Bengal chapter and West Bengal chapter, previous occasion was supposed to held Epicon in 2024, which was not happened. That 2024 Epicon was happened in Delhi. So 2025, now the West Bengal chapter's turn came in, and they are going to organize Epicon in 2025. That Milord, my letter is there.
What is the present injunction you are seeking?
Not only not to give effect to this Milord purported resolution, so that Milord the whatever decision that
which resolution?
Milord, Milord, I have. My injunction application, 21st of September 2023. Milord, page 86 and 87, prayer B. And Milord, if your Lordship takes up the order, Milord, that is under challenge, that records nothing. Having heard the learned advocate plaintiff petitioner taking the entire facts and circumstances to consider, this court has come to a conclusion that it would not be appropriate to pass any order in the case without hearing the other side.
One other thing, Mr. Mukherjee, at page 58, it states that that a meeting of the API governing body of API will be held on Sunday, 5th January 2020.
Yes.
At UP, Agra UP. But the next thing you show is a 15th January 2020.
No, that is Milord the ratification.
That
Milord, that records, Milord, this is Milord, your Lordship will get Milord, this was going to happen on 5th January 2020.
But this refers to a meeting held on 6th January.
6th January.
Not on 5th January. So how do you know it is the same thing? Because if we have to connect the dots, we have to connect, because page 58 speaks about 2024 Epicon. And page 66 says that in the meeting, but that also refers to Epicon 2024
that,
in any event.
In every event,
even without page 58.
And Milord, the next page also your Lordship will get Milord the this is a letter Milord that my client was Milord page 59, second paragraph. That my client was selected as organizing secretary by the decision of 75th annual general body meeting held on 6 January 2020 for the venue of Epicon 2024 at Kolkata, West Bengal chapter. Due to the COVID-19 pandemic situation, this conference will going to happen in Kolkata on 2025. As per letter.
That is your letter.
That is my letter.
The impugned order gives no reason.
Milord, nothing, Milord, if your Lordship takes up that, only, Milord, apart from that, the presence of the other side is required, Milord, nothing is being discussed.
The appeal has not been admitted because we
Milord,
wanted to hear the papers. The in the order dated January 13, 2025, we had recorded that the present appeal arises out of the refusal of an ad interim injunction, and that the learned trial judge refused the ad interim injunction primarily on the ground that it would not be appropriate to pass any order without hearing the other side. Full stop. The matter pertains to a conference scheduled to be held from January 24th,
23 to 26.
24 to 26?
Oh, 24, right. No, my lord, yes, I stand correct.
From January 24 to 26 this year. Keep
The matter parties to a conference scheduled to be
held
from January 24 to 26 this year.
By the Association of Physicians of India, within bracket API. Full stop. We also recorded in the said order that we are faced with a conundrum that if the relief as sought at the ad interim stage is granted, comma, it might tantamount to granting final relief in the injunction application and the suit. While, comma, on the other hand, comma, if refused, comma, the suit as well as the injunction application in the court below might be rendered infructuous. Full stop. To obviate such situation, comma, we had deemed it proper that the appellant serves a copy of the application along with a copy of the memorandum of appeal on the respondents and to file an affidavit of service today, comma, with the intention to give an opportunity of hearing to the respondents even at the stage of admission under Order 41 Rule 11 of the Code of Civil Procedure by carving out an exception to the said provision. Full stop. Next para. The affidavit of service filed today indicates that the primary contesting defendants stroke respondents have been served. Full stop. However, comma, despite such service, the respondents choose not to appear when the matter is called on for hearing. Full stop. Next para. The appeal arises out of an order of refusal of ad interim injunction where the learned trial judge did not attribute a single line of reason for refusing to grant such ad interim injunction, apart from having observed that before granting any order, comma, the contesting defendants should be heard. Full stop. Next para. However, comma, we cannot wait further in view of the extreme urgency as today we are on January 20, 2025 and the appeal may be rendered infructuous in the event not taken up, comma, since the concerned conference is scheduled to be held between January 24 and January 26. Full stop. Next para. We find from the annexures to the, in view of an arguable question having raised as to whether the learned trial judge erred in law in refusing ad interim injunction as well as refusing ad interim injunction without considering the extreme urgency involved, without attributing any reasons, as also that the learned trial judge failed to advert to all the grounds taken by the appellant. First of the appeal is accordingly admitted and will be heard on the grounds taken in the memorandum of appeal. First up, can 1 of 2024 is now taken up for hearing. First up, from the annexure at pages 48 to 57 of the application, comma, we find that the same is the memorandum of the Association of Physicians of India, where the constitution of the said body has been enumerated. Pushed up, clause 17 of the same speaks about annual conference of API and provides that the West Bengal branch of the API, comma, from time to time, comma, may get the responsibility to organize APICON, puro block, within bracket, annual conference of API, bracket closed. Under such situations, comma, clause 17 further provides, comma, the names of organizing secretary, comma, organizing chairman and organizing committee has to be proposed by EC committee of API West Bengal branch, comma, which is to be confirmed by the general body meeting, GBM capital, of the API West Bengal branch. Full stop. Next para. We also find from an email dated December 23, 2019, comma, annexed at page 58 of the application, that the API had written to the present appellant stroke petitioner, informing him about a meeting of the API governing body to be held on January 5, 2020, comma, the agenda of which was for bidding Epicon 2024, full stop. Next para. Again, comma, we find that in a general communication, comma, captioned as within double inverted to whomsoever it may concern, double inverted close, dated January 15, 2020, comma, annexed at page 66 of the application, comma, the honorable the honorary general secretary of the API, comma, India, within bracket India, bracket India, certifies that as per the decision of the 75th annual general body meeting, CAPSE, held on January 6, 2020 at Agra, comma, the application received from API, comma, West Bengal chapter for the venue of Epicon 2024 at Kolkata, within bracket West Bengal chapter, comma, the organizing chairman was nominated to be one Dr. Mrinal Kanti Roy, and the organizing secretary was nominated to be the present appellant, Dr. Shibendu Ghosh. Full stop. Next para. We further find from an email dated June 28, 2023, annexed at page 112 of the present application, that as per Epicon norm, comma, the headquarter of API was supposed to send a letter to the state chapter asking name of organizing secretary, which would be adopted in governing body meeting on 24th February at New Delhi during Epicon 2024. Full stop. For such purpose, comma, the API West Bengal chapter was to decide a name of the organizing secretary in its EC meeting. Full stop. Next para. The appellant argues that the said initiation of a fresh exercise to appoint organizing secretary for the 2024 Epicon, comma, which has since been postponed till 2025, comma, was dehorse the constitution of the API in view of a prior ratification having already been made by the Association of Physicians of India, comma, ratifying the appointment of the present appellant stroke petitioner as the organizing secretary for such Epicon. Pushed up. Next para. We find further substance in such contention from the letter dated October 18, 2023, where it was written on behalf of the petitioner to the Association of Physicians of India that the petitioner was selected as organizing secretary by the decision of the 75th annual general body meeting held on January 6, 2020 for the venue Epicon 2024 at Kolkata, within bracket West Bengal chapter. So it was further mentioned that due to the COVID-19 pandemic situation, comma, the conference was to be held in Kolkata on 2025. Pushed up. Next para. Again, comma, sorry. We find a communication addressed to the learned advocate of the petitioner dated November 14, 2023, which states that API, West Bengal had its executive committee meeting on September 21, 2023, which was attended by the petitioner, which was allegedly attended by the petitioner, and it was concluded that the approval of the petitioner as organizing secretary had not been approved by the executive committee prior to or after January 5. Push up. Next para. However, comma, in view of the specific ratification dated January 15, 2020, annexed at page 66 of the present application, comma, which was issued by the Association of Physicians of India within the contemplation of clause 17 of the Constitution of the API, comma, nominating the present appellant as organizing secretary for the 2024 Epicon by its meeting dated January 6, 2020, comma, there was no scope for further appointment of an organizing secretary. Push up next para. Since the 2024 Appicon has been averred in the injunction application, comma, which is uncontroverted till date, comma, to be held between January 24 and January 26, 2025, and as the appointment of the petitioner as organizing secretary for such Appicon was ratified on January 6, 2020 and communicated in the certificate dated January 15, 2020 by the apex body of API, comma, we find a strong prima facie case having been made out by the appellant to go for trial on the issue as to whether the respondents acted dehors the constitution of the API in reinitiating an exercise of appointment of a third party as organizing secretary for the 2024 Appicon to be held between 24th and 26th January 2025. Pushed up. Accordingly, the respondent numbers, which of the respondents should be restrained?
Respondent number 1, 2, and 3.
The respondent numbers 1, 2, and 3 are hereby restrained by an order of injunction from appointing anyone else than the present petitioner, present appellant stroke petitioner as the organizing secretary to represent for the purpose of holding Appicon 2024 scheduled to be held between 24th and 26th January 2025. Full stop. The respondent numbers 1 to 3 shall further remain restrained from giving any effect to any decision, comma, if taken to the contrary. Full stop. Such injunction on both counts shall operate till February 28, 2025 or until further order, comma, whichever is earlier. Full stop. The respondents and all concerned shall act on the communication of the learned advocate on record for the appellant, comma, coupled with a server copy of this order for the purpose of compliance, comma, without insisting upon prior production of a certified copy. Full stop. The application shall be listed on February 10, 2025 for passing further orders.
Great.
হ্যাঁ তাছাড়া ডেলিভারেটলি যদি না 24 তার এরপর তো একটু হয়ে যাবে ওর ইচ্ছে করে অ্যাভয়েড করছে যাতে এখানে এক্সপার্টি অর্ডার না পায়
Lord, I'm led by Mr. Chaudhary, my lord. Mr. Chaudhary is in court 26.
And I'm sorry, my lord.
Praying for a not today, my lord.
One last. This is the second time, my lord. I have to.
No, then we'll have to hear you. Yes, Mr. Shen, what is that? This is order 41.
Yes, my lord. Order 41. I'm coming up against, my lord, a final order whereby an injunction has been granted in respect of enforcement of 2 debit notes raised by my client. It's practically, my lord, in contravention of section 41B of the Specific Relief Act. But it relates to a commercial contract. A plaintiff has relied upon 2 confirmation notes, which I have issued through a broker for sale of goods to the plaintiff. There is also, and that is also in the plaint. The plaintiff has also relied upon an email saying that asking for a delivery date. Thereafter, plaintiff makes out a case that he has received no intimation, but I have given him a letter asking him for delivery, asking him for lifting. That's an advocate's notice. Advocate's notice has not been replied to. Thereafter, I have given him a mail saying these are the 2 debit notes because because you did not lift, I had to sell it. This is his case in the plaint also. I'll show your lordship to first the confirmation note which he has relied upon. Then he has an email saying give me the delivery note. Then my advocate's notice. There is no letter from him saying that since there is no fixed delivery date, I am cancelling that confirmation note. Nothing of that sort in the plaint. Now, I filed a
debit notes were admittedly issued by them.
By me.
By you.
Yes.
They have admitted that.
And he
What
had
is that defense against that? I mean, what do they make out? What
his
case?
plaint case, he asked for cancellation of the debit notes.
Well, my case is that there is no concluded contract between the
Yes.
parties. Well, those debit notes, there were communications, there were
That will be
communications.
decided in a suit if they file it. How can you injunct them from filing a suit?
I do
Because
Not from filing a suit, my lord. Only the thing is that there was some communication between the parties. We have only asked them by way of
what
a
injunction has been granted?
Yes,
Let us
Your
see.
Lordship will see the nature of the injunction.
Without any cost, granted by.
So I think
all
Your
right.
Lordship, I have to.
Order number
Your
2 has to.
Lordship, the first order. Certified copy to the first order.
Order number 2 has to be looked into.
But this is arekta copy. I just hand over to your
Isn't
Lordship.
it annexed somewhere? Is it?
Somehow, my lord,
The
they have not
entire
annexed
records
it.
as reflected in the impugned order have also not been placed before your lordship.
I'll come.
No, we'll
I'll come to everything.
definitely.
The impugned order I will place. This is the other copy. Kindly see order number 2, second page. Considering documents, court finds there is prima facie case in balance of convenience also lying. So the respondent is restrained by from giving effect or further effect or acting in terms of in furtherance to the debit note. I cannot even raise a counterclaim for this amount.
So you can make a counterclaim or file a suit for recovery of that amount.
I want.
Mr. Shen, would you be satisfied if for the time being we, we stay the operation of the injunction subject to hearing? We are not making it final.
But I have other points also.
No, we'll take
more
that.
fundamental.
No, because an injunction has been ultimately granted.
In a commercial suit, that is again my point.
Jurisdiction question also.
Yes, this is a and I had taken that point in my order 39 rule 4.
So if you get an injunction, suppose the injunction order is stayed with the rider that you can only enforce these debit notes by way of a
counterclaim
or a suit.
Yes.
Otherwise, you cannot enforce.
How will I enforce? Well, if I may ask myself this question, I am not a bank, or this is not a bank guarantee that I will, without reference.
This is in contravention of 41B.
That is what I'm saying.
That's the only thing is, with respect to this stay petition, at least, my lords, I have several submissions to make, my lord. One is the entire records are not before your lordship. They preferred an order 39 rule 4.
This sort of injunction, we are on a more fundamental question.
Yes.
Whether this injunction can be passed at all in view of the bar of section 41(1)(b). Because you cannot restrain a party from initiating a proceeding, a legal proceeding, before any collateral forum or except from a subordinate forum. Now they can institute a counterclaim. That injunction cannot be granted because you cannot restrain somebody from initiating a legal action. That much we find palpably, even without going into anything. Even if you have a very strong prima facie case otherwise.
But that also has been found that they do not have a prima facie case. And I have not been able to show a prima facie case. I do not know why I will be required to show.
The respondent number 2 in
Final
the
order
present
if your
appeal.
lordship comes once.
The respondent number 2 in the present appeal is not before your lordship today. I don't know if they've been served. They were before the lower.
They are at the order 41 stage.
I was not required to serve them also.
We'll grant an ad interim injunction and direct them to serve on them. You are not also required to be served.
In the lower court, they have appeared. The written objection taken by the respondent number 2.
Well, let Mr. Sen place the order.
Yes,
Mr.
So I have shown your lordship the ad interim order first.
Yes.
Because this is merely a continuation of that ad interim order. Now, if your lordship seeks the main impugned order.
See the yes.
But it is annexed to the memorandum of appeal.
Yes, the main order we are.
Yes.
Not.
The first part is if I may kindly come to the operative part, if I may show, because this is recording the plaint case. I will show the plaint, my lord. If your lordship kindly comes to the last page on perusal of the documents.
No, Mr. Shen, let us read the entire thing because what case was made out by you, what objection was taken by you, whether you took the point of jurisdiction.
Yeah, but that is not recorded. I have the order 39 rule 4 here, which is annexed to my objection. Specific jurisdiction, but that is also my submission. If I raise a jurisdiction point which goes to the
jurisdiction point, you can raise here also if it's
yes,
if it
that
goes
is what
to the
I'm
fundamentals of
yes, fundamental. But kindly see my
objected to that, my lord.
You don't have a right of hearing at this stage.
Kindly come to just one paragraph of my order 39 rule 4 where I've taken this point.
No, that is taken subsequently.
When they got an ex parte ad interim order, I filed it order 39 rule 4.
That 39.4 was pending when this final order was passed.
It was disposed of together.
So
dispose
so
of
then we
it.
can look into that also.
But I'll just show your lordship
So
kindly.
that has also been decided. Let us see. It has not been adverted to.
There is, yes, kindly come to.
Oh, yes. Consequently.
Yes.
So then we can look into that.
Kindly come to page 99 of the stay petition.
Yes.
I've specifically seen. Paragraph 11, if your lordship comes. That was territorial 11. Well, paragraph 12. 11 is territorial and 12 is commercial, my lord. Page 105.
And the trial court was not a commercial court.
No, it's a civil court, my lord. 2C Roman 18.
No, there is a designated commercial court in the
Yes,
civil
in
court
civil
also.
court, but this is
This was not that.
Civil.
Section 6.
And specified value is also above, my lord, the
2.5 crores.
2.5 crores.
2.5 crore is above specified. And the transaction is obviously commercial.
Commercial, 2C Roman 18.
You have given, yes.
I have the notification also, my lord.
Regarding the valuation.
Regarding the valuation.
Yes, we'll take.
In case of B, in case of commercial court within the territorial jurisdiction, city civil court of an amount not less than 3 lakh and more than 10 lakh exclusively, exceeding 10 lakh but not exceeding 1 crore concurrently with the commercial division of the.
This was, what is the valuation of this?
Well, they have made a valuation of 100, but if the debit notes are being challenged.
No, they have made a valuation of?
Your lordship comes to.
What is their
valued at 100, injunction valued at 100. If your lordship sees the debit note which is under challenge, debit note is valued at 2.5 crores.
Last page.
Declaration, kindly see prayer A, page 29. Declaration that the contract, even the contract value is more than 3 lakhs.
B says in case of commercial courts within city civil of an amount not less than 3 lakh and more than rupees 10 lakh. So minimum has to be 3 lakh.
3 lakh.
2.5 crores.
Crores.
So then concurrent jurisdiction with us.
Concurrent jurisdiction. No, it is exclusively with the High Court. Exceeding.
Yes, right.
1 crore.
Maximum 10 lakh.
Yes. Your lordship sees the debit note.
1 crore, up to 1 crore is concurrent.
Yes.
10 lakh to 1 crore, right.
And your lordship sees the confirmation note which they have annexed to the plaint, page 35. Even that valuation would also show. Quantity 250 metric ton, price 1305 per 10 kgs. And the debit notes are at page 42 and 43. One is 1 crore 19 lakh and the other is 1 crore 25 lakh.
Page 42 and 43.
42 and 43.
Yes. Right.
This is, my lord, with regard to the first point that if a jurisdiction point is taken, even if I do not have any Order 7, Rule 11, at the stage of deciding an interim injunction and prima facie case, the jurisdiction point is a bar for having a prima facie case. That is number one. Number two is, my lord, if your lordship sees without going into the merits of the plaint, kindly see the prayer. Final relief has been granted at an interim stage, whether it is permissible in this fact situation. Rarest of rare cases, I was just hearing your lordship's last judgment. If the balance of convenience is such that an interim relief has to be granted, which may amount to a final relief, that is the only exception. So, my lord, here if your lordship sees prayer C of the plaint at page 30, that is practically been granted. And
no, but need not necessarily mean that, because if a restraint order is sought,
giving effect to.
No, in the previous case, the dates are fixed between
understand.
24th and
So
26th.
therefore, I
That
say,
is not your here. Final relief is not being given as such.
if you are
Because injunction, temporary injunction means at the suit, you can after the suit, if they lose the suit, then you can always.
But is it not, my lord, in the temporary injunction?
Then in every permanent injunction suit, all temporary injunctions will be granting final
Well,
relief.
it's the manner in which we seek the temporary injunction in aid of the final relief of injunction.
Yes, this is in aid of the final relief. They seek a final relief, they challenge the debit notes, and they say that there is no concluded contract.
And they say that don't give effect to the debit note at all.
Yes, if they have made out a case of null and void, the debit notes being null and void, that is their prayer B in the plaint, relief B.
Yes.
So
that
this is in aid of that, not a
Whatever,
final.
but
That is not.
prayer
We're not impressed with that so much.
Very well.
Yes.
I do not press that.
Don't press that one much. Yes.
Prayer C
Yes.
is hit by the section 41B of the Specific Relief Act. And now your lordship will kindly see, test the order impugned on the principles, my lord. Kindly see now, I am not going to trouble your lordship with the entire recording of the facts. I will, after I show your lordship how the conclusion has been arrived at. If your lordship feels that this is a way of arriving at giving an injunction, then I will go into the fact a little bit. Now, your lordship sees the last page of the impugned order.
Yes.
On perusal of the documents annexed with the objection, it appears defendant has not annexed any document to make out a prima facie case that such contract as alleged in the advocate's letter has been entered in between the plaintiff and defendant number 1. Though it is admitted that 2 confirmation notes dated such and such were received by the plaintiff from the defendant number 2 regarding supply of 500 metric ton crude palm oil from the defendant number 1. This is the plaint case. Confirmation note is there. It is the claim of the plaintiff that since no definite date of shipment or delivery of the goods was notified to the plaintiff either by defendant number 1 or by the defendant number 2, no further step was taken by the plaintiff for securing the supply of the goods, and the defendant number 1 is not entitled to payment as raised in the debit note, as there was no concluded contract in between them. It is already stated that defendant number 1 did not produce any document containing those contracts. The contracts are already annexed. As agitated by advocate of the in his letter.
Contract, you say that confirmation notes are the contract.
Confirmation notes of the contract. They also say that. But they say that since you did not come forward with any definite delivery note, there was no further obligation on our part. This is the kind of statement. I will show your lordship. But point remains that so-called confirmation note, you did not withdraw, or you did not say that since you are not giving us a delivery note, that confirmation note stands cancelled. It is of no effect. There is no contemporaneous correspondence from your side. I cannot rely today, but there are documents to show that there are correspondence asking them for lifting. But without going into that, I am trying to say this one now. Kindly see thereafter. And since question of having concluded contract in between the plaintiff and the defendant cannot be decided unless the suit goes on to trial, I am of the view that in the absence of any such document to attain the prima facie satisfaction for existence of the contract, the plaintiff has made out a good prima facie case. So he is looking for documents from my side to give the plaintiff.
But the court can say that because their allegation is there is no concluded contract. If you say there is a concluded contract,
he says, if your lordship now takes the plaintiff, he says that this is the contract.
But
thereafter, it did not take place. Paragraph 4 of page 24, your lordship will see. I'll read from paragraph 4.
Yes.
Plaintiff in the usual course of business at the business requirement of crude palm oil of a designated quality. Requirement would be around 15th of July. Plaintiff was aware defendant number 1 was importing crude palm oil into India, and in those circumstances contacted the defendant number 2 and inquired as to whether the said defendant number 1 would sell such product to the plaintiff. Defendant number 2 is the broker, agent. Such approaches were made to defendant number 2 in or about May 2022. Defendant number 2 was unable to immediately refer, and ultimately by an email dated such and such issued 2 documents termed as confirmation note agreeing to ship crude palm oil in such and such but without informing exact date of shipment of delivery.
You are the defendant number 1.
I am the defendant number 1. Copies of the emails are annexed here to and marked with the letter A. This is their confirmation note. Plaintiff by email requested defendant number 2 to indicate whether it would arrange a vessel by mid-July, a copy whereof is annexed here to mark with the letter B. So he acts upon that confirmation note and seeks the confirmation.
But he can say that something more was to be done because there is a
Then he has to cancel that confirmation note. He cannot let it remain outstanding. And he has not even replied to my letter.
Where are the debit notes mentioned?
No, here, I'll come to that. Kindly thereafter come to my advocacy. Kindly see, defendant number 2 failed to confirm sale or confirm delivery on or about 15 July. In the said circumstance, nothing further fructified, no contract therefore came into existence. This is his case. Plaintiff was surprised to receive a letter dated 20th December issued by the defendant number 1's advocate, wrongly contended that there were 2 alleged contracts dated such and such, which had been entered. This is a previous contract between plaintiff and defendant number 1. It was further incorrectly alleged that the plaintiff has failed to lift the goods. Plaintiff was called upon to lift the required goods. 20th December letter, if your lordship kindly sees once, my lord.
There are correspondences also.
38, page 38.
Kindly come to page 38. 59. But your lordship can see it page 59 also. That is part of the injunction.
Yes.
59, your lordship?
59,
yes.
yes.
So this is our legal notice addressed to them.
Do you refer to those confirmation notes here? July and August 22? Because you said that was the contract. You refer to something else first.
Just 1 second. Yes. Kindly see.
You refer to a contract number such and such dated 16th August 22.
And 29th September based on the
shipment arrived.
The date of the shipment. This is based on that shipment.
What shipment?
Shipment of these goods. When the goods have come and arrived at the port, it is thereafter that lifting order has been
These
given.
contract numbers you have referred to specific contracts which are not produced by you. That is the finding of the court also probably.
But these are actually based on the 2 confirmation notes. Once the confirmation note comes, the goods are shifted, imported here.
We don't know without looking into the contracts. How can you know that they are linked to those?
Then, my lord, kindly see if this is the notice thereafter.
No, in the plaint, do they refer to the debit notes? Obviously, they have to refer to because it's an injunction.
Kindly come to the next paragraph of the plaint.
Yes, let us continue with that because in what context they mention the debit notes, we'll also have to look into that. They say they were surprised to receive this letter.
Yes.
In which you refer to different contracts.
Then they come to paragraph 10 and 11. Page 27. Plaintiff states that contract dated such and such have never been entered into. There is no obligation to lift goods. Plaintiff has not authorized the defendant number 2 as act as broker. The documents are on record.
But in your letter also, Mr. Shane, you referred to those 2 contracts, to particular, not on the consignment notes.
But this is the same.
So the consignment notes may be the genesis of the contract.
Genesis of the contract.
But in the absence of those contracts, I mean, you don't even,
But if you
produce those contracts.
Kindly see thereafter once
they flatly deny that there were 2 contracts of that date.
Then
and
paragraph 11.
Yes, let us see that.
By an email dated such and such, defendant number 1 alleged incorrectly that plaintiff is what required to make in respect of the debit notes dated such and such. Now kindly see my email.
Let us see that. Yes.
This is just after the advocate's notice. Email 65. 65 Kindly come to page 65.
Yes.
I am writing to them Refer to our legal notice. You were called upon to leave the goods by 26 December. Since you omitted to respond to the said notice, we had no option but to close the contract as per prevailing rates of 26 December. Debit note in this regard is attached. Now, kindly see, even in their plaint.
But what do we get the terms of the contract from the consignment notes?
From the consignment note.
Will
Price and my lord, they have not annexed here the entirety of the terms and conditions, which we have disclosed in our written objection with jurisdiction clause and everything.
Page 147.
If your lordship now sees my written objection once.
But let us see the consignment notes and the debit notes once.
Yes, consignment note is page 56. 56 and 57. These are the two. Kindly see commodity, lifting, 10 days from PHO. PHO is port clearance. It is there is nothing, no further term can be imported here unless parties further negotiate. Then shipment, I will arrange for shipment, already mentioned in the consignment note. Price,
They say you did not arrange, probably regarding the shipment. They don't say that.
they have simply said that they have shown one email.
The delivery date was not.
Delivery date was not, but there are subsequent correspondence with.
And where are the debit notes submission?
Debit note is page.
This contract entered between.
Just kindly see once, just after that, below the table at page 56.
Clarification.
This contract is entered into subject to general terms and conditions for the purpose of oil and fats and the bylaws of the Indian Vegetable Products Association. We have brought in our capacity as broker for both the seller and the buyer, subject to the law of agency and other contracted for being in.
General terms are 147.
And the detailed terms and conditions are at page 147. It is attached to the confirmation note. On page 145 and 146, I have annexed the confirmation note and then the general terms and conditions of sale thereafter, which is part of the confirmation note. There is an arbitration clause, there is a jurisdiction clause. Details are there. And I am not going for this purpose of the reasoning given in the impugned order with regard to the detailed merits of the matter.
And where are the debit notes?
Debit notes are page. Kindly come to 63 and 64. This is the rate difference. This is the only usual principle of section 73 of the Contract Act. I will have to prove this. The difference in the rate, contract price and the price at which I had to subsequently sell. So that right has been taken away now. If I am granted a perpetual injunction from giving effect, giving effect is a very wide term. My right to pursue this contract or this claim has been virtually taken away. That is number one, my lord. Kindly see my learned friends are saying about no further. I am relying upon some of the documents appended to the injunction application. Kindly come to page 58. This is, kindly see, they are writing at the top, please arrange vessel in mid-July 22. Thereafter, this correspondence with the defendant number 2, please find vessel nomination for below trade. A1 Agro Products is the plaintiff. And this one, the trade date is 10th May 2022. This is the confirmation note date. So whether it is this the case is this not a foolproof case by them that since I did not give you a firm delivery date that the contract goes. The confirmation note is a prima facie document of the contract, which you have followed it up by seeking a delivery date. You have not given documents to show the further correspondence between your broker, who is entering into the contracts for both of us, regarding the lifting dates. And there is nothing in this confirmation note to say that a full contract cannot be inferred from this. Now, this is on
It's
the
arguable whether there was a concluded contract.
Yes.
If it's arguable, they have a prima facie case.
If it is also arguable that there is a prima facie contract,
yes.
What is the injunction they are seeking?
41B is there.
Yes.
That remains, and commercial code.
This is the issue in the suit. Has to be an issue in the suit, whatever case they have made out or whatever.
That's the prime issue in the suit.
That existence of a contract. I cannot go in for my claim for damages unless I can show the contract and the breach. That is a prime thing.
So you say at least you are entitled to make a counterclaim
for damage for my debit note.
Yes, on that debit note.
Debit note. So if this
blanket injunction cannot.
Blanket injunction in this fact cannot come.
And also the suit valuation should be commensurate with the debit notes.
Yes, suit valuation and therefore prima facie I say the order cannot be sustained subject to correction, my lord, because the court has not even noted my demurrer point on jurisdiction, which goes to the root of the court's jurisdiction to act upon the case, my lord. But the point is well settled, but my juniors have found out one judgment where it says, this point, but if a jurisdiction issue is raised, that becomes that the court has to take into consideration at a stage of grant of interim relief.
Obviously, that's a part of the prima facie case.
That's the part of the prima facie case. Just
I think Mr. Chaudhary will
I don't
refute that proposition as a proposition.
Provided it's taken.
My order 39.
39.4, Mr. Chaudhary.
There.
Yes.
Para 13 or something, 16.
Para 11 and 12.
99 it starts.
At paragraph 11 or 12.
12 probably. 12, Mr. Chaudhary. 12 it's taken. Para 12. Squarely taken.
And there is no whisper. My lord, your lordship will see paragraph 39.
Yes.
Paragraph 38 onwards. 38 and 39.
Written objection.
Needless to observe, question of jurisdiction has to be determined at the commencement, not at the conclusion of the inquiry. Although not directly arising in the present case, we also wish to observe that the question of jurisdiction would have importance even at the stage a court considers the grant of interim relief.
Yes, my lord, it's part of prima facie case. If your lordship, my lord, feels court has no jurisdiction, overwhelmingly your lordship will not grant interim order in the best of
apologies. And one more judgment, my lord, on the following Cotton Corporation. I'm not citing Cotton Corporation, following that, my lord, AIN 99 Calcutta 200. And I have, my lord, also in my written objection disclosed similar contracts entered into by and between the parties through defendant number 2, and which has been worked out in the same manner. Confirmation note followed by lifting, import and lifting.
Specifically fact specifically fact.
Appeal has been. This also is right saying, my lord, kindly see the order restraining the appellant bank from enforcing 2 bills of exchange.
Which paragraph?
First paragraph, first line, my lord.
Yes.
Appeal has been. Then, my lordship will kindly see paragraph 10 and 11 is the suit, prayers in the suit. Then paragraph 13. The order is quoted. I pass an order in terms of prayer D of the petition. Now, prayer D has been quoted in paragraph 14. Injunction restraining defendants from seeking to demand any payment from the petitioner in respect of bills of exchange without first making payment of the sum due from the defendant number 1 to the petitioner in any manner whatsoever. There was still some difference, I say, in this. And here it is a blanket prayer that you can't enforce it. Then, my lord, paragraph 18 and 19.
18 Cotton Corporation and 19
yes.
consequential.
21, 22. this.
Yes, 41B. Right. Yes. So, একটা order record করো, the appeal in view of an arguable case having been made out to the effect that the learned trial judge did not take into consideration the objection raised by the appellant as to jurisdiction of the civil court, since the dispute is apparently a commercial dispute within the contemplation of section 2 within bracket C within bracket X V triple I bracket close of the Commercial Courts Act 2015, as well as whether the injunction granted by the learned trial judge violates section 41 within bracket small b of the Specific Relief Act 1963, comma, the appeal will be heard on the above questions and the other questions raised in the memorandum of appeal. Full stop. Yes, we have heard you on the application also. Let us hear Mr. Chaudhary, then we'll decide.
Just 1 minute. Paragraph 3 of the plaint, page 24, they have made out a case that they never knew me. Plaintiff number 1 is not aware of the.
No, you acted to the broker. The broker on your behalf
has never had any form of business relation or connection with such entity.
How is this material?
Material, no, material is
Oh, okay.
Previous transactions through the defendant number 2 and
Yes,
which are direct communications. Which
They've
I have,
admitted those previous transactions.
yes, I have annexed in my affidavit in opposition, in the written objection to those. And this is to show the suppression. All aspects, my lord, of coming with clean hands, injunction, all those, my lord.
Well, yes, Mr.
Yes. Lord, firstly, Lord, let me deal with Commercial Courts Act. Lord, Commercial Courts Act, there must be a commercial contract.
Yes.
An agreement between two parties. If
Yes.
there is an agreement, disputes arising out of that agreement will go, Lord, to commercial courts.
The dispute is regarding commercial, whether there is a
Yes,
concluded
there
contract.
is no contract. So I can't, my lord, say that this is
The no
the
contract
commercial-
claim is in respect of a commercial transaction.
No, my lord, please see how the language is worded.
CPC কাছাকাছি থাকা উচিত কমার্শিয়াল কোর্টসে।
Lord, commercial dispute.
Let us just have a copy first. Hey.
No, this will come under 18.
দেখাও এই
Subsection
বইগুলো দেখি।
2, 1, 18.
Read out the provision for us.
I'm sorry, my lord.
No, that's your only copy.
No, I take it out.
No.
That's soft copy.
No, the two copies you are giving, then you won't have.
No, kindly give me 1 minute.
Yes, yes.
Lord, Section 2, subsection 1 says commercial dispute means a dispute arising out of A. Now, my lord, come to subsection 1, 18.
Yes.
A contract of sale of goods. So, my lord, disputes must arise out of a contract. Plaint cases, there is no contract. Can never be a commercial dispute as per statements in the plaint.
18 you say?
Agreements for sale of goods.
Yes.
So, my lord, dispute under section 2,
Commercial
subsection
dispute
1,
arising out of, yes, agreements.
dispute arising out of an agreement for sale of goods.
So we have to decide whether that
yes,
non-existence of an agreement also is a dispute.
Non-existence, my lord, would not
All right.
be a dispute.
All right.
My lord, if your
So
lordship
declaration you are seeking that, yes.
having, it's my only and specific case, if your lordship holds, my lord, that there is a dispute, then, my lord, it will be a commercial suit. So that's, my lord, that's why this can actually never go to a commercial court. Number 2.
All right. 41B.
I'll come to 41B. 41B, my lord, when I injunct, my lord, kindly see the way the prayer is couched.
Yes.
It says, don't give effect to the debit note.
Or acting in terms of or in furtherance of.
Yes, of the debit note.
Yes.
Restraining the defendants from giving any effect or further effect or acting in terms or in furtherance to the debit note dated 26 December and debit note dated 26 December in any manner whatsoever. And my lord, prayer B, declaration that these debit notes are illegal. And my lord, prayer A is declaration that the contract has not come into existence. The prayers B and C, my lord, are restricted to debit notes. They are not, they have no bearing on the claims. Nobody is injuncted from filing a suit on the claim. I have not obtained an injunction restraining a claim. I cannot, in view of
The
section
existence
41.
of the debit notes is admitted. That
No, they
there
have
are
been-
physically such debit
They
notes.
have been given to me.
Yes.
When a debit note is given to me and I do not accept the debit note, I've asked for cancellation of this document. He may have a claim. He can go to court. He can file a suit. He can get a decree against me.
He can he today, after this injunction, file a suit on the basis of those debit notes?
There is no bar. Where is the bar?
They have been injuncted from giving effect to or
Kindly
acting
see,
on
my
this.
lord, the order. This court finds that there is prima facie case in favor of the plaintiff and balance of convenience is lying in favor. So the respondent is restrained by an order of injunction from giving any effect or further effect or acting in terms of or in furtherance to debit note.
Now they can act in terms of the debit note but filing suit. One is
No, my lord, suit is
or
on
counterclaim.
the basis of a claim. Suit is not on a debit note. Debit note is a document created as a result of accounting procedure. I am entitled to ask for cancellation.
Then what is the way in which they can give effect to the debit note?
Filing a suit.
So that is precisely what has been
No,
injuncted.
to give effect to the debit note. No, not you.
How can they give effect to a debit
Yes,
note?
it's possible. My lord, they can raise a claim on several, my lord, trade bodies, etc. That there are monies which are owed to me.
This debit note is issued by them to you.
Yes.
So
my lord, they can
how
allege-
else can they give effect to the debit note apart from filing a money claim on the basis
No,
of
no, my lord. For money claim, they need a claim. They don't need a debit note. My lord,
Then
even
debit note
without
will
the
give the
test
basis.
is, the test is even without the debit note, there is my lord, a suit which is maintainable. If I don't issue a debit note and I file a suit, that suit is maintainable. So therefore, my lord, if I issue a debit note, that has nothing to do with the suit. Lord, if your lordship comes to a
Debit note means that you agree in a sense to pay him the money, or not exactly that.
No,
I have raised a claim.
No, debit
for
note
payment from him.
means
In
debit
my
note
accounts,
his right.
in his account, it is debited.
Right.
And so I have to make a claim for that.
Correct. I agree. His accounts are reflecting that I owe him 50 rupees. And he is giving me an extract of his accounts. So, my lord, that is, it's got nothing to do with claim. Now, my lord, I'll just show your lordship the facts. I'll show your lordship the facts. And the most crucial thing which is not shown to your lordship, possibly my learned friends not aware of this. This is the affidavit filed by the broker.
That's recorded in the judgment that he has denied the agreement. I have also the documents otherwise.
Now,
Broker has filed a suit.
No, in this, I'll come to it.
What is this?
I'll
Written objection?
keep unraveling the deity.
This is
The thing is that I also have certain documents to show in that case.
Yes.
no. This
Then I'm sorry, one of them is a marked copy. Doesn't matter.
is easier for us. So debit note, the broker has denied.
Yes.
Everything.
Now, my lord, please see this. Let's see, my lord, how it starts. There are 5 documents. Document number 1 is page 35, which he says is his version of the contract to me. My lord, please see 35 and 36, the 2 documents.
Confirmation notes have been denied.
This is not what he has issued. This is what the broker has issued to me.
Yes.
My lord, please see who's KNG.
Broker.
KNG
Yes.
is 2, the broker.
Broker. Now, my lord.
Broker is denying page 56, 57
No, no, no,
also.
no, no, no. 35, 36. He's not denying this. And I'll show your lordship. So this is what is issued first. Now, my lord.
35, 36, yes, 35, 36 are
But 35,
the same
36,
document. Page 56 and 35
now,
are
my
the
lord,
same.
kindly first look
35,
at.
36 and 56, 57 are the same document.
My lord, please look at 37 now.
Yes.
Let's see how it starts.
Yes.
This is 4th of July 2022. Please arrange vessel in mid-July 22. This is us writing A1 Agro Products from Amit at A1 Agro. We write to, my lord, this is to Prasanna Gadre. Now, my lord, kindly see, this is KNG. Kindly see who's KNG. KNG is broker. Lordship has seen that.
To KNG is forwarded
to broker that you give on mid-July. Please arrange vessel in mid-July. Now,
you are writing.
Yes, I'm writing.
But in furtherance of that confirmation.
Now, my lord, kindly see below. This is, my lord, first email is 222. Below that is 1301. Please find nomination for the below trade and or substitute vessel.
And the trade date is the date of that first
10th
confirmation.
May. Yes, confirmation. 10th May, A1 Agro, KN Commodity Safe, Kandla.
So you act
It-
on
it
that
is
confirmation note. You
I'm
act on that confirmation note.
No, 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 my lord. I'll just explain. I'll just explain. My lord, what happens in this trade is the buyer and the seller are never in contact with each other.
Broker in between.
Broker in between. And my lord, we are also traders.
Yes.
My lord, buy and we my lord, send it to somewhere else. So, my lord, it has to match. By the time it gets off the ship, it will get onto my ship, or my lord, get onto my trucks, etc. So, my lord, when I ask the broker gives me, when I make inquiries with the broker that I need this bloody crude palm oil in mid-July, I need a shipment. Broker sends me this. It's not confirmed. Then I send a message saying that mid-July, etc. Then nothing, my lord, happens. From July, nothing happens till, my lord, 20th of December, because there's nothing confirmed. My lord, I wanted a ship by 15th of July. Otherwise, I wasn't interested. Now, my lord, see the broker's affidavit. This is not blackmailing, really. My lord, kindly see, my lord, this part is explained. My lord, please come to. Yes.
If the existence of the Yes, sorry. Yeah.
I'm sorry. Yes. So, my lord, the first part is I make an inquiry. I am given, my lord, page 35, 36, but 35, 36 is open-ended. My lord, please see shipment, July 22. Broker issues these documents.
Broker on behalf of them.
Not on behalf of them, broker. No, yes, yes, yes. You can't say that.
No, see the first sentence. As brokers, we confirm having concluded.
Conclude on account of the parties mentioned below the following transaction. Shipment is July 22. I want 15 July. So, my lord, page 37. Please, I say that please arrange vessel in mid-July 22. It's not possible. It's not done thereafter. Now, please see the broker's affidavit. So if this was done, Milord,
No, up
kindly-
to this, Mr.
Milord,
Chaudhary,
just
that-
one thing to Milord, put a germ into Milord, the whole thing. Please look at 35.
but the
If
35 is why is 35 and 36? Why are they not the concluded contracts?
Milord, if 35 and 36 were concluded contracts, the shipment date is July 22.
Yes.
When does he demand shipment? December.
No, your
Milord, just imagine for a moment that 35 and 36 are concluded contracts.
you have asked for arrangement of the vessel in mid-July 22.
Correct. But if this was a concluded contract, then Milord, July 22, Milord, goods would have changed hands.
May not be. You may not honor the contract.
No.
But you say there was no concluded
Then your
contract.
lordship must see the first.
Otherwise, there
demand
will be no
notice.
suit for specific performance
No,
of
no,
contract.
Milord, please see 38 now. Let me place these, Milord.
Yes.
Milord, paragraph 1, we write to you in relation to your continuing failure to fulfill your obligations under contract number such and contract number such and such. Contract date is August 22 and September 22. Not May.
No.
Not what your lordship saw. Now, for purchase of 500 MT of crude palm oil. Now, this is below 250 and 250. So, 500 MT matches to lift the goods within the timeline. You are aware that you entered into a trade deal with our client through a broker, one KNG Commodities, to purchase the goods that were to arrive in India on board should be MV, Golden Lotus and Coca-Cola. It was solely on the basis of your representation and express intention to buy the goods from our client that our client sourced the goods. However, for reasons best known to you, you have now refused to lift the goods and pay the amount due to our client. Please note that the outstanding amounts due and payable by you to our client under contract number such and such, dated 16th August 22 as on date is as under. Contract value, interest, storage charges, total, etc. It goes on.
You have not sought any injunction regarding this letter.
No.
So they can still file a claim under on the basis of this letter, on the basis of this contract.
No, they can file a claim against even the debit subject matter of debit.
You say that the debit notes are maybe the premise of the claim, but they are not the. You are not restricting them from making the claim. That may be one of the components.
May I, Milord, use this expression? It is one expression of the fact that they have a claim. Neither have I injuncted the claim, neither can I injunct the claim, nor would I be in a position to injunct the claim from being carried to a court. Now, Milord, kindly see this. Paragraph 6. You are called upon to lift the goods and make payment of the amount to our client by 26 December. Failing which, we will sell the goods to a third party. So this is below December. I wanted goods in July. And below the two contract numbers don't match at all. Let's see the contract numbers dated 16th August and 29th September and compare with page 35. Milord, my learned friend proceeds. 35 is a concluded contract. I'm entitled to payment. Now, and you had to lift the goods. Now, Milord, please compare with page 38.
But their claim, this is their only claim.
This is the only claim. Now, I'll show your lordship more. The full fraud.
No, but this claim is on a different contract. Let us proceed on that premise.
Exactly.
You have not asked for any injunction on
Anything
this.
with regard to this. Now kindly, now see the debit note. Now please see the debit note.
Yes, debit note.
Page 63.
63, right?
Yes. Now please see this. This is Golden Lotus 250. Rate difference MV, MT, Golden Lotus 250. Crude palm oil. Document date 26 December 22. Document number DBOOT.
Yes. This is a
That's
debit
your
note number.
debit note number.
Yes.
You know, the interesting part is apart from Golden Lotus and 250 MT, there is nothing that will connect the debit note to, my lord, page 35
Page
and
64 is
36.
Coca-Cola.
Yes, my lord. One is Lotus, one is Coca-Cola.
So these debit notes pertain to their claim of December 2022. Page 38.
Arising out of these two contracts?
So how do you link this? You say that there was no concluded contract on the basis of those page
Now-
35, 36.
Now, my lord, the interesting part is, so let's, my lord, look at this. At page 35 and 36,
Yes.
we, my lord, have two documents issued by the defendant number to the broker,
Yes.
which, my lord, are totally different from the contracts which are referred to at 38 and in the debit notes.
Yes.
My lord, because the number and the vessel, my lord, are different.
So the debit notes, the vessels mentioned in the debit notes, they
Yes.
tally with their claim at page 38.
The, my lord, vessel.
Coca-Cola and
Yes. Your lordship is right.
so then debit notes are relatable to page
To the
38.
contract numbers.
Yes.
Because Coca-Cola and Lotus.
Yes. Then
Now,
how
my
can
lord-
you get an injunction on the debit notes on the basis of there being
Now,
no
my lord,
concluded contract on the basis of this?
kindly see what the broker says.
Mr. Chaudhary, we are on a different issue. Now,
Yes.
therefore, there is a link apparently between the debit notes and page 30, December 20th, that email, that claim,
That claim.
which refers to two separate contracts.
Correct.
Now, you claim that by virtue of this confirmation notes, no contract was entered into, no concluded contract was there.
Yes.
Even if you get that relief in the suit, how do you connect these to the debit note? Those are, the debit notes are based on independent contracts as mentioned in the December 20 document.
Paragraph in page 38.
38, yes.
Yes.
You are not seeking a stay on that. I mean, you are not challenging the contracts mentioned in at page 38. Two contract numbers are given and the debit notes are relatable to those.
Lord, please see my print now. I'll just
Yes.
reconcile it.
Even if there is the confirmation notes don't create a concluded contract, those have no connection with the debit notes. Debit notes have a connection with that December 2022 contracts. So that's a different chapter altogether. How do you get an injunction order on the debit notes, even if there is no concluded contract on the confirmation notes? Confirmation notes and debit notes have different numbers, different contracts.
Confirmation notes being contracts is my learned friend's case here before your lordship.
You have obtained an injunction in the court below,
Yes.
restraining them from acting upon those debit notes. Debit notes mentioned vessels which are mentioned at page 38.
Yes.
December 20th, 2022.
Yes.
December 20th document mentions two contracts.
Yes.
So the debit notes are relatable apparently as per your annexes to those contracts, which are mentioned in page 38. So then
So
it's a
is
different thing.
Now,
Confirmation notes are a different chapter.
let's just see prayer A of the, let's forget confirmation notes for 2 minutes, my lord. Now, my lord, please see prayer A of the plain.
Where is that?
At page 29.
Yes.
Now, please compare the two contract numbers in prayer A.
Yes. These are, so confirmation notes have nothing to do with that. Your prayer is on that was what we were wondering, because otherwise how do you connect?
Now I'll show your lordship. Your lordship is absolutely correct. Now I'll show your lordship what is.
So
my
you
plain
don't
case.
make a prayer regarding the confirmation notes even.
No. That is my inquiry. I've said so.
It's Mr. Shen who tries to link the confirmation notes with the debit notes, right? He says confirmation notes themselves are concluded contracts and therefore debit
Lord, he runs a case of, my lord, there being confirmation notes being concluded contracts.
Yes.
Yet, my lord, his demand notice having a different contract number and his debit note not mentioning anything.
Mm.
This is situation.
In the order 39 rule 4, how do they make
Now,
out?
one very crucial, my lord, the main person. My lord, please take this.
Broker
affidavit.
broker refutes everything.
No. Absolutely not.
Then?
My lord, please see. My lord, page. My lord, this is page 3. Not
Of the one you handed over.
advisedly not annexed.
It's not paginated in our copy, you can
Not
make
paginated, not annexed. Not,
No, you have not paginated it.
no, my broker has it.
Achha, but we don't have a pagination. How do you refer
I'm
to
sorry,
page
my
3?
lord, third page.
Which clause?
My lord, A.
Yes.
This point number 2 is a broker of different commodities, including crude palm oil. This point number 2 works as broker between plaintiff and this point number 1. In on May 22, this point number 2 approached the plaintiff regarding supply of crude palm oil by this point number 1. So, my lord, this point number 2, when a broker approached me for supply of crude palm oil by my lord, Mr. Sen's client. This point number 2 made all endeavor to answer queries raised by plaintiff. Thereafter, this point number 2 sent 2 emails to the plaintiff in relation to shipment of total of 500 MT of crude palm oil, which are Annexure A. Now, my lord, please see Annexure A. These are what they say are contracts. Same document, page 35, 38. Copy down now.
Yes.
Page 35, 36.
Consignment notes.
Yes. On 4th July, the respondent number 2 received a mail from the plaintiff inquiring whether the vessel can be arranged in mid-July 22. Copy of email dated 4th July is annexed. That's also there in the plaint. Next, please arrange vessel in mid-July. Next, after just 2 pages of annexure, third annexure. Right at the top.
Third annexure?
Yes, my lord. Third annexure, my lord.
Yes.
After this, they filed it by Firisti. So, my lord, the Firisti and the third annexure. So, number 3. My lord, please arrange vessel in mid-July 22.
Yes, that.
Yes.
So, same document.
Then, my lord, upon receipt of the petition, the respondent number 2 appeared before this learned court on date fixed of hearing on date, that's irrelevant. Then, on 16th March 23, respondent number 2 received an email from the plaintiff. By the said email, plaintiff inquired respondent number 2 whether contract numbers such and such had been received by respondent number 2. Please see the 4th document now. You are, please confirm that, page 4, my lord, please confirm you have never received contract numbers such and such for purchase. Answer is, you are right, we have never received such and such for your contract.
That you say to them, to the broker.
Yes, I say, please confirm that you have never received.
Achha.
My lord, at 3:43. And, my lord, on 21st March 2023, which is, my lord, 5 days later at 4 minutes past 12, he writes back, says, dear Amit ji, you are right. We never received contract number KNDL such and such and KNDL such and such. Instead, we received 11 and 14 for your contracts. Now, Lord, please see his statement. In such, respondent number 2 was unable to shed light on contract numbers such and such 44 and 60. Now, if your lordship goes back to the petition at page 48, that email, at page 59, 44 and 60 are the 2 contracts. Now, the broker, so nobody's seen the contracts. He's not produced the contract.
How has he linked the confirmation notes with the contract in his order 39 rule 4? Let us see that.
Yes, let us see that. I'll show you.
Case also has.
Absolutely. But he's also filed a written objection.
Kindly see the written objection.
I'll show very well. Let me show.
Where is the written objection? Page?
Page 68.
Para 8.
Now, my lord, what will become very clear is, Lord, I want your lordship to see, Lord, page 69. If your lordship sees his case, your lordship will, Lord, appreciate the entanglement of the various issues. Lord, say page 69, 5 lines from the top. As a matter of fact, in November 2021, the plaintiff applicant had provided its KYC documents to the answering defendants for the purpose of customer registration. These documents were submitted by the plaintiff by its email dated 3rd November 21, issued to its broker number 2, and the answering copy of email dated 3rd November is annexed. In the month, now Lordship must see this. This is, my lord, page 83. From their person Govind Rao to my lord KNG. Customer registration. Could you please arrange below KYC detail? So my lord, they write to the broker asking for KYC details, and they whatever documents are required, page 84, all of that is given, and the documents are from page 85 onwards.
Now, what is the case? What is the pleading regarding the connection between the confirmation?
So they are saying that we had provided, as in the plaintiff had provided KYC documents to the answering defendants in the past. So we were known to them and we've had transactions before. In the month of January, plaintiff even transferred advance money to the account of the answering defendant, and this fact can be ascertained from email communication between us. This is some other transaction. So he's just trying to show that, my lord, we have had transactions in the past. In support of the facts mentioned in the preceding paragraphs, it is submitted that details of transaction taken place between plaintiff and answering defendant, seller, buyer, goods, etc., etc. Now this, my lord, is in respect of some other vessel called Jasper, whatever had come. And this is January, past transaction. Now, my lord, after this, paragraph 5 at page 70, it is submitted that plaintiff had engaged with the answering defendant and defendant number 2 in a commercial transaction in the past, and owing to the said fact, it approached defendant number 2 in the month of May 22 for purchase of 500 metric ton of crude palm oil. This had been admitted by the plaintiff.
Their entire case in the order 1304 and the objection must be on that those confirmation notes.
Paragraph 8 advance, your
Next page, 71.
77. Paragraph.
In fact, the last sentence at page 70 also.
Yes.
2 lines after this, my lord. So I had allegedly approached them. This was admitted. Pertinent to mention here, plaintiff applicant has not disputed the confirmation notes that had been issued by defendant number 2 and shared with the plaintiff and the answering defendant. These notes are dated 10th May and 18th May, confirms the sale transaction. It is reiterated plaintiff had accepted the 2 confirmation notes. The confirmation notes recording the sale transaction in clear and unequivocal term had put the answering defendant under an obligation to initiate the shipment
Page
process.
8, para 8, Mr. Chaudhary, they say that the further contracts are in furtherance of the confirmation notes. But nobody produced those contracts.
Nobody.
And the broker
He can't produce it. Broker says, I've never seen it.
disowns the.
Yes. And the demand made by Amarchand Mangal Das in December of that year is on the basis of those 2 documents.
And the debit notes also referred to the vessels mentioned in those
2 documents.
Those 2 contracts.
And, my lord, if I had closed a deal, assuming, my lord, I inquired in May, I closed a deal in July, and then I said I want my ship on 15th July. My lord, admitted position is from May till, my lord, December 20th, there is not a single message.
So even today, Mr. Chaudhary, despite your obtaining this, I mean, they have it open before them to
File a suit.
To file a suit on the basis of those confirmation notes,
yes,
seeking whatever declaration.
Yes.
You only seek a declaration that these contracts referred to never came into existence.
Correct.
and the debit notes are connected to those. Therefore, consequentially, I've sort of
Exactly, my lord. Please see for section. There are two sections of the specific relief act. One, my lord, is 41.
ওরা দিল আবার আনিয়েছেন রিলেট তো ওরা দিয়েছে
My lord, please see 41. My lord, we keep
কমার্শিয়াল কোর্ট
saying
একটা
this.
আনিয়েছেন কিন্তু স্পেসিফিকলি একটা আনেননি
My lord, 41.
yes
Huh?
which clause
My lord, 41A. Injunction cannot be granted to restrain any person from prosecuting a judicial proceeding pending at the institution of the suit.
this is not applicable you're not
Not applicable.
B,
Then
B.
B, to restrain any person from instituting or prosecuting any proceeding in a court not subordinate to that from which the injunction is sought.
that is their argument
Yeah,
You're doing
where does the court
the debit
restrain
note
them?
they cannot make a claim on the debit note
That's their imagination
what is their imagination
that they can't go and file a suit.
on the basis of the debit notes
No, not debit note they can't be.
if
Milord,
debit notes be the premise of the suit
Milord, first of all, an order
but
of
per se if you seek an injunction relating to the debit notes it may not tantamount to 41B you may argue that
Milord, there is no
not going to that
restraint.
extent yes
Milord, there is no injunction issued by a court restraining him from filing a suit.
so they say that the effect is that
Milord, for example, we Milord make a claim, then don't injunction restrain respondent from giving any effect to this demand. But that doesn't mean that he can't file a suit. You can't go and Milord tell others. You can't go and Milord
the
call
civil
me a
courts
defaulter.
regularly we refuse as a civil court injunctions restraining someone from giving effect to a loan agreement to making a claim on the basis of a loan agreement because you are restraining surface proceedings by virtue of that although there's a surface act bar also on that
That is a
civil court.
different matter.
No, not only that making a money claim I mean in the nature if it's in the nature it may be veiled not giving effect to some document which is the premise of the
Milord,
of a
a
money claim
debit note really is a creation of accounting procedure where Milord you generate a document intimating to a third party that my books show
debit
that
note
this
is after all not a promissory note given by you I mean no obviously not a promissory note but I mean if you obtain an injunction restraining them from invoking a promissory note or something
That's a
like that
different
that
matter.
would be probably 41B bar would
That's a
come in.
different matter. That's a different
Very
matter.
good, very
Now, Milord, also see this.
Hmm.
Milord G, paragraph G of the broker's affidavit. In such
So two
circumstances,
sections you are saying well what are the section
and the other one, Milord, is under which I have sought for cancellation. Milord, please see section 27. Or any document, Milord. I'm sorry, 31. Any person against whom a written instrument is void or voidable and who has reasonable apprehension that such instrument, if left outstanding, may cause him injury, may sue to have it judged void.
yes always you have to do that only
So that's why I have taken, Milord, that document. The other document, the contracts, Milord, are not available. What is available, I have taken it to the gallows, Milord. I want it to be cancelled. And I've said, don't give effect to it. If you had a claim, you could have done that. You could have filed. Milord, he hasn't even filed a written statement in the suit till today. Suit has proceeded ex parte. He's not even entitled to make these arguments before your lordship. Now, also, Milord, please look at the broker's affidavit. Milord, paragraph 6. It is reiterated that the respondent number 2 was not authorized as broker in relation to contracts being numbered KNT.
yes those they have been denied
They have denied that.
So let us go back to Mr. Shen then. Yes. So you have made out a case that first of all, section 41B not attracted. Secondly, no commercial court act. Thirdly, that their entire claim is based on those two contracts which are non-existent. You have sought for that.
Seen them.
And
In
debit
fact,
notes are relatable to those.
Yes, debit notes are relatable to those. And my lord, even when he's filed his stay petition and he's filed his 39-4 and he's filed his written objection, he's not produced those documents, those two contracts.
Please don't. Please don't. Yes.
Last fact, if I may
Yes.
indicate, which I wanted to connect earlier. Please, that payments were made. I am sorry, I got distracted a little. In December comes the July, this is all genesis of May, June. Then December comes first demand.
Yes.
Now December demand means goods have come then because they asked me to take delivery. And they're also asking for little retention charges. So therefore,
in December they say they have brought the goods earlier, you are not taking it, take it.
Yes, but
otherwise they'll sell it to others.
So now
that doesn't necessarily mean the goods came in.
Attacking Mr. Sen's argument that the first page 35, 36 is the contract, where then the contract is shipment in July. If contract says shipment in July to December, you go all quiet. This is all perishable. Suddenly in December, you issue something. Page 35, just for repetition, Milord, because this I want to make a point that this is unbelievable.
July, yes.
Yes. Page 35. Mr. Sen says 35 is a contract.
July and August. Yes.
So July and next page is August.
Yes.
So if goods come July, August, perishable crude palm oil, after July and August, you go quiet, not a word spoken, till the time comes page 38, 20th December 22.
Yes.
And then what do you say? You say that you lift the goods by 26th December, within 48 hours. Such is your urgency, with Christmas in between. Please see page 39, para 6. So 20th, Milord, you start and you want within 6 days, and you're now pretending that this is a contract which comes up in July, August. Milord, it's an unbelievable story. If it was a July, August shipment, if that was the contract, then the goods would have come in July, August and not in December.
Yes, Mr. Chaudhary, we have heard it. Yes, Mr. Sen. Yes.
Milord, with your lordship's leave,
my learned friend has relied upon the broker's affidavit heavily. Now I'll show your lordship, my lord, why this is an entirely collusive proceeding. Everything has been suppressed, whatever correspondence we have, my lord, if your lordship kindly see.
Sir, Shen, we cannot go into the merits so much. You show us the link between the consignment notes and the debit notes.
But for that, I need to show your lordship 2 or 3 documents, my lord. Just emails.
No.
Admitted emails.
No. As per your order 1304 case or your written objection case, you are jumping from the consignment notes and say in furtherance of that two contracts were made. Now the debit notes conspicuously refer to the ships which are mentioned in your December 2022 letter.
Yes.
But nothing, we don't find anything to connect those confirmation notes with the December 20 claim or the debit note.
I'll tell your lordship why. Because, my lord, the confirmation note.
You are bringing in the confirmation note.
Yes.
And you are trying to link that.
He had brought in.
He had brought in, but he is seeking a declaration that this December 20th, this claim, I mean, the contracts referred to there, those are non-existent. And the debit notes also consequent thereto
because
should be injuncted.
Yes, why I tell your lordship, not the genesis, as your lordship says, agreement for sale fructifies into a conveyance. There may be a direct conveyance, but there may be agreement negotiations leading to agreement for sale.
There's an inherent fallacy in this argument, Mr. Shen. If you say that the consignment notes were the concluded contracts, what was the necessity of entering into further contracts in furtherance with those?
I say that there was no further contracts.
That is your argument in
Well,
furtherance.
it is like an invoice. Once the goods come, I have to raise an invoice on them.
Then it's arguable. They have made out an arguable case.
Kindly, my lord, hear me only.
And you make your claim in December for the first time. They come and take
So
you.
that is what I'm saying. I have given them the lifting request for lifting is going on from August.
This will be decided in the suit, Mr. Chairman.
Now, my lord, now I am not saying.
They made out a sufficient privacy case for injunction.
Now, my point, I will only restrict myself to the aspect of how this kind of an injunction could resist my lawful claim. Now, kindly just let us concentrate on that aspect of the matter, my lord. If your lordship sees the prayer giving effect to or acting in furtherance of the debit note. This is the prayer.
Yes.
Now, my lord, if I have to file a suit for recovery of this damage amount, I have to obviously rely upon the contract and the debit note, because that is a piece of my evidence. Debit note is the evidence of my assertion that the amount of claim has been levied on them. Lordship knows in the suit we have to bring forward our accounts.
But this is not akin to 41B. This is not on the same footing as 41B. As rightly pointed out, Mr. Chaudhary, under 31, and it's well settled that any instrument can be challenged. They have challenged an instrument, the debit note, saying there is no basis to it.
Yes, but
they have a right to. This is not 41B.
No, I am not saying that prayer B is not permissible. Prayer B, they may
So
see.
C is also not on a footing of 41B.
But kindly see this context. What is the necessity of an injunction in this case? Can I go and attach their property?
No, the debit note is based on your, they say, fictitious contracts of 2022.
Suppose, so then, my lord, in my suit, if this suit is decreed, then I can never pursue my suit for recovery under that contract. Because
precisely.
I can never, so my suit goes.
So therefore, they cannot challenge a contract.
No.
They say they cannot say a contract is non-existent.
I am only on the perspective of interim injunction pending trial.
Yes.
Because suppose, my lord, there is no injunction, the suit is pending. I also will have a right to file a suit or bring a counterclaim, whatever this in this suit.
Even today, I have a right to file a suit on the basis of the confirmation notes. But these contracts you have not even produced those contracts.
My case is that confirmation notes lead to contract. Contract leads to the debit note.
They don't seek a declaration regarding the consignment notes. Go and file a suit on the basis of the consignment.
But I will not. But
there's a conflict.
But I cannot kindly appreciate, my lord. Mere confirmation note does not lead to my claim.
Mr. Chen, you have not been injuncted from relying on the confirmation notes. You have neither been injuncted from relying on these contracts.
On the debit notes.
Debit notes is a component of your claim.
But debit note is my principal claim.
Debit note is enumerates the quantum of the claim. Debit note is not a claim.
Of course. But the quantum of the
debit
claim.
Note is your debit note. You have issued.
But without the debit note also, kindly see, the language is very wide. If your lordship clarifies this, I will not argue much. But language of this prayer is very wide. In furtherance of the debit note, make any claim concerning, and once the debit note your lordship has looked into, that embodies the contract, the vessel, the materials out of which this claim arises. It is only a piece of evidence.
Debit note is by no stretch of imagination a contract.
No, I'm not saying it is a contract, but the language of the prayer, if this language is...
Independent of this, you can rely on your consignment notes. And if you have those contracts,
of course,
regarding which declaration has been sought, if you have those contracts, file the contracts, get a file a counterclaim also on the basis of that.
Only thing, my lord, I will not be able to rely upon these debit notes.
Not for the time being.
Yes, that is, my lord, that will affect my right in the suit. Suppose, my lord, I will show as evidence that the goods have come. Apart from the contract, the goods have come. I have to rely on the invoice. Once the invoice comes, it is related to the debit note. Then they will raise a question that you cannot indirectly do or bring in evidence which you have been injuncted. But it is interrelated. Debit note is only a piece of evidence which I can rely upon to show that I have levied a claim on you under this contract. Now, in furtherance of this debit note means wide. That your lordship will have to, my lord, kindly protect me in whatever word. Otherwise, my right to recover is being taken away. I bow down to your lordship's observation that debit note is only a solitary piece of evidence in the entire transaction. Of course, but the language in it which is couched, that will, my lord, impair my remedy and right. That is number one, my lord. That I leave it to your lordship in whatever way your lordship will protect me. Because, my lord, in an injunction, my lord, as your lordship says, my lord, it's a balance of convenience. Today, he has every right to ask for cancellation of debit note, cancellation of contract. But what is the injunction in this case? It is not like that the bank is going to attach his account on the basis of a debit note. That we come and say for railway demands, that they can adjust from my other contract. There is no case of this. It's the two private parties. The only right which is available to me under this debit note is to prove it in a instituted suit or as a counterclaim. But if it is taken away by this language, then, my lord, then it will come under 41B. If everything is taken away. That is number one, my lord. Second aspect is the Commercial Courts Act.
Yes,
Lordship, my lord, kindly tease the language. My lord, I think it is, my lord, it is a dispute. Commercial dispute.
Yes.
Means a dispute. Dispute is a very wide word. All forms of dispute, which will encompass existence, non-existence, annulment, cancellation, everything.
There is a difference between disputes arising out of and relating to. If it was a dispute relating to an agreement, then we could have given a wider connotation, liberal connotation. Yes, it's a dispute relating to the existence of the agreement, can also be relating to. But here it is arising out of. It has to arise, emanate from that agreement. So therefore, the agreement has to be a given.
Then, my lord, kindly.
They gave one step behind. They challenge the existence of those agreements themselves.
Yes.
So if that be so, if there are no agreements, there cannot be any dispute arising out of. If you filed a suit today on the basis of certain agreements, then it might come within the commercial disputes connotation. But they challenge the existence of an agreement.
In a county, suppose a plaintiff files a suit.
Yes.
And the issue becomes, my lord, the enforceability and the validity of the agreement. Even if a validity issue is also raised, then because it is coming out of the word dispute, and otherwise it is kindly considered in a suit for specific performance.
Yes.
In a suit for specific performance of an agreement, or in a case where an agreement is being challenged relating to immovable property, possession, and even, my lord, non-performance, non-existence, everything will has to come up. Then, my lord, suppose I file a counter claim and I say that this money is recoverable. Then, my lord, what the question will arise, that it becomes a commercial dispute, because it is a counter claim in this suit. I will obviously file a counter. Given a chance, I will not go to a separate court. Or suppose now, my lord, if lordship holds that it is not a commercial dispute, but for my claim I have to go to a commercial court, and now, my lord, two courts will be pitted one against the other in point of time, racing who can get a decree first. If they get a perpetual injunction and a declaration, then my suit goes. So that cannot be the purpose of the Commercial Courts Act. Because specifically the court even says, and rightly so, that the issue is whether this contract is the existence, whether there is a breach. Now, for this issue, it is only the commercial court which can come under 218. Because as I pointed out, if your lordship, in certain cases, your lordship has to give a purposive interpretation. Or as I say, subject to correction, a contextual interpretation. If your lordship considers dispute very, very strictly, as in some cases your lordship does, and the example is in relation to is not there, then what happens to a defendant's counterclaim?
No, you have a very good point in arguing that yes, an issue may arise even in a suit arising out of an agreement, that the agreement existence of the agreement is disputed. Then that issue has to be decided. So then will the
because every dispute arising out of agreement for sale, because What is a dispute? Dispute is assertion of fact and denial of that fact.
But there's a difference between the two, Mr. Shen, because the claim that then the claim, because we have to see the frame of the suit
Yes.
for ascertaining the whether it's a commercial dispute, not the written statement. The frame of the suit. If your suit is a claim arising out of that a sale of this agreement 8 agreement for sale of goods or such and such, if the claim is that, and if there is a dispute regarding the existence of the agreement, then the suit is a suit on a claim arising out of an agreement. The dispute cannot be a decider of the nature of the
No, I am not saying that, but I am saying,
but here they are filing the suit. The suit is based not on the agreement. It's not arising out of a claim from the agreement. It says there is no such agreement.
No, but kindly consider, my lord, this is determination of this is not strictly demurrable. Your lordship will have to see, while deciding a meaning of a dispute, here what else they have said in the plaint. Because there is a prayer for cancellation of the debit note. Debit note cannot be anything but a commercial transaction or a commercial dispute. The element of dispute has to be culled out, my lord, not only from one prayer of the plaint.
All right.
It is the entire substance of the plaint that has to be looked into. Suppose your lordship sticks to prayer A and says, no, it is not a dispute arising out of an agreement. Then prayer B. Every prayer has to be decided by the suit court. And a debit note may be cancelled, but debit note presupposes a commercial transaction.
Mr. Shen, why doesn't it come under Commercial Courts Act?
I was thinking C2 also.
C1 also. Why not?
Ordinary transaction of merchants, bankers, traders. Yes.
That is wider, such as
Much
those
wider.
relating to
all transactions,
including enforcement and interpretation of such documents.
interpretation of such document. And also,
You have specifically argued Roman 8, that's why you are dealing with Roman 8.
it says that
Your Order 39 Rule 7 says that.
So that is why.
Obviously, that is why you are arguing also. But why not? Because if you give that limited interpretation.
I did not personally check this, but while discussing, I was thinking of 2. Now that your lordship says 1, I think
Yes, because if you give
one is wider.
If you give a limited interpretation to the Commercial Courts Act, the very purpose of the statute will be frustrated.
Absolutely frustrated. And then this problem also, my lord, as I said, my lord, issue has to be framed. The issue will go to the nature of a dispute being a commercial dispute. But even in respect of dispute, my lord, may not be related to this case, but I remember, my lord, one case where there was a case of payment of money. Even non-payment of admitted due is also a dispute. There one cannot say, no, I am saying there is no dispute because there is...
No. That's on the dispute aspect.
Dispute. I am also saying on the dispute aspect, if it is a wider meaning to be given, I need not, since your lordship has given the answer. I would rather rely on C1 or 2 rather than 18. If 18 creates any problem, and this is a fact, my lord, which the defendant need not plead under which subsection.
Because these are ordinary transactions as merchants or at least
traders. If of nothing else, traders. And then obviously, the question will come, how will you interpret that confirmation note? As my case in the written objection is, confirmation note has led to the...
Yes, because the suit is wider than the injunction granted.
Yes.
You take an objection to the maintainability of the suit before a civil court.
Yes.
The suit encompasses the declaration regarding those contracts, and the debit notes also.
And the debit notes. Kindly see all the prayers also, because debit note...
Existence is admitted, debit note, but
Yes,
they said
it is not binding.
Illegal, null and void.
Not binding. Delivered up and cancelled.
And cancelled means it should be.
To set it aside. Existence is there because they have received it, they have annexed it.
Yes. Yes, do you have any answer? We'll ask you specifically because the argument was made by Mr. Shen on 8. Therefore, what is your answer to one? Mr. Sen, we have heard you. Only on 8.
And that also, my lord, if your lordship is against on the commercial dispute point, kindly consider, my lord, my submission with regard to the form. If your lordship says that injunction has to be granted, but some form of the injunction, so that my ultimate right to recover the money
yes.
under the debit note is not taken away.
Very.
That is all.
Yes, yes.
My lord, since we have challenged the existence of the contract itself, as rightly pointed out by your lordship, if there is not a contract, there cannot be a dispute because 2,
It cannot come under 8.
Cannot come under 8.
Why not 1 and 2?
Even, my lord, I am relying on a judgment of the Delhi High Court, which says that in 21C1, which your lordship had pointed out, if there were no documents, the suit was held to be filed not in the commercial division, wrongly filed in the commercial division, my lord.
No
May I
documents
cite-
too?
No documents.
No,
to show
debit
that-
note, you are seeking cancellation of debit note.
My lord, debit note, my lord.
Regarding the
point
contract,
that-
you are right.
My lord, with respect to what Mr. Sen said, that the other
Your
proceedings are
cancellation,
barred.
declaration and cancellation is regarding a debit note.
Debit note, my lord.
Two debit notes.
I understand, my lord. Now, my lord, there is no bar on going as reading order number 2, 16th January. There is no bar if the same claim arises from either the contracts are produced or the invoices are raised, which have not been done in this case.
Maybe,
the
but
debit
you are
note-
seeking an injunction. In the suit itself, you are seeking a declaration and an injunction regarding 2 debit notes. Debit notes are obviously a part of the ordinary transactions of traders, which relate to enforcement and also export or import of merchandise.
This particular suit, my lord, that
why not
we
1 and 2? Both. This is relating to export. They are exporting, importing. So, and if you give such a strict interpretation to commercial disputes, you know the consequence.
I understand.
Every suit will be filed before the civil court. And some form or the other, there will be a challenge to the existence of that agreement. And
My lord, may I submit on this tomorrow, Mr. Chaudhary, if we can, because we were prepared for these 2 answers, that why not 1A, because there were no documents. But with respect to this,
but this is a query of the court. But it was not
contract-
put to Mr. Chaudhary. You are right.
contract, my lord, as well as the invoices, if they are able to produce, their suit can
If
lie.
you can bring Mr. Chaudhary before 4:30, we will try.
I shall
So
try,
we
my
have
lord.
heard it only on his answer on this. One, if he can't come today, just be there. Keep somebody there at 4:30. We'll
Very
put it as the first thing tomorrow morning.
Very well.
But he'll have to assure. You will have to assure. You are the defendant number 1 here, defendant number 2 here, and
one.
he is the defendant number 1.
Okay.
So you have to assure for him that he will not take more than 5 minutes on
Very
1 and 2.
Very well. Very well.
But we'll wait. If he comes by that
I
time,
shall
we'll call on the next matter.
Oblige.
Thank you. এটা ওদের বইটা ফেরত দিস।
The suitটা কবে আছে জানো?
We are also sorry for being loud. I mean, because you are not hearing us, that's why we have to shout, not to demean you.
Suit
এটা
is for
Yes.
judgment on 29th
judgment
of the suit. On 29th, I had shown your lordship one.
Judgment of this suit
Yes.
on 29th of January.
29th of January.
Evidence is over.
Evidence is over, and on the website,
Whichever way we hold Mr. Sen, it will affect the decision of the suit.
No, my lord, it
The
has
order
to
is
be done,
dated
my lord.
June.
Otherwise, my lord,
If you either way,
if
whatever
it
you
is a decreed, then the decree will be anyway without jurisdiction if it is a commercial dispute.
no, even then
It
it
is
is
better,
at the degree stage, Mr.
No, my lord, what I had shown your lordship, my lord, how the thing has
This
progressed.
must have been one of the issues in the suit, whether it's barred under the
There
commercial
was
court.
no hearing at all. We could not give any evidence, nothing. My lord, kindly see only one thing. My lord, I had shown your lordship probably. It is now arekta website copy. The date was the order was.
Anyway,
But only this thing is very important. At 16th December, it was fixed on 10th January for evidence.
but that is on a different aspect. We cannot.
But
Why
not
should we look
different,
into
but
this?
it is already uploaded the next date.
The impugned order, my lord, was June 2024, and it's these 7 months, my lord.
And my lord, kindly see the entire evidence is also on the debit note. Entire evidence has been given on the
It is on
debit.
the verge of being decreed or dismissed, whichever way. Then why should we interfere?
They hadn't come up with the.
No, I am not on that. I am only saying this, my lord.
No, we are on that. Because the suit is scheduled to be, the judgment is scheduled to be passed on 29th. We generally don't interfere at this stage because you have suffered injunction for quite a long time.
No, only thing, my lord, nature of the
Whatever
injunction,
points you have taken here, you will be entitled to take in an appeal if the degree goes against
but the
you.
nature of the injunction will have a bearing on the suit.
No, no.
Because if your lordship,
At interim or interim.
no, your lordship will.
If we say something from the High Court, it will be difficult
No,
for
no,
you.
but the point remains that not this.
Know the reality, Mr. Sen. Whatever we say, not by tentative, may have some bearing.
And it is
Should
going.
we interfere at this stage?
Because
If you are informed, we would not trouble you so much. I mean,
we have not got a hearing also, my lord, there, my lord. That is the difficulty.
that will be a point in your appeal, where all these points will be open. These are good points.
Very well, your lordship will kindly decide the legal issue at least, my lord. This is
very well. Then try to bring Mr. Chaudhary. Inform him if he can come now.
Very well.
Very well. We are passing tentatively an order that it will be taken up tomorrow. Heard the parties, heard counsel in part for further hearing. The matter will be listed tomorrow at the top of the list. But if he comes, we'll cancel this and we'll hear him on this and close our vote.
I'll just take him.
But we have heard virtually the appeal itself. We were hearing the injunction application.
Yes.
If both of you agree, we can decide the appeal itself.
Yes,
Ask Mr. Chaudhary whether
but that is
you are agreeing, but whether he has to.
We thought, my lord, your lordship is already hearing the appeal.
No, we did not think so, but at the start, but now we think so.
Yes, yes, my lord.
We heard the merits of the appeal. Ask Mr. Chaudhary.
Very well, my lord.
So whether if he agrees, then we'll. ठीक है, सेगुलर रेखा. Yes. For
My lord, in this matter, you lordship may remember.
Yes.
I filed first appeal, my lord, you lordship granted leave to correct the.
You have carried out the correction and now it's affirmative.
Regarding my lord application.
What is the Act 8 case?
Act 8 case. Permanent custody matter. In the permanent custody matter, initially, my lord, you also filed from the my lord memo appeal list of dates, my lord.
You are the father.
I am the father.
So visitation rights were given to you.
Visitation right has not been taken, has not been given effect to. Initially, we filed application before the Lane district judge at Barasatmal, North Parganas in 2021. Then one of they have filed an application under section 9 of the Guardian and WhatsApp to the jurisdiction.
Mr. Dattu, you won't be able to finish in 6 minutes.
Tomorrow, my lord, on this topic. My lord, the father is since 2021 is not getting access to.
And what is the interim order for? Visitation?
Visitation.
The application for?
Application for stay and the visitation. Only visitation.
Yes, what do you say?
You also already decided this issue earlier.
Mr. Banerjee, you are for the other side. So visitation, would your client agree to anything? No.
But court has to have the jurisdiction to pass this order. But they initiated the proceeding before the civil court. But family court has now been formed.
Your lordship decided these issues. I have brought that to your lordship judgment, my lord.
But I can show to your lordship.
Then, my lord, may I be permitted to?
He's doing you a favor by taking the objection point, the demurrer point, so that you can address that also. Any other demurrer point, Mr. Banerjee?
The other judgment.
There is a family court, therefore city civil court did not have jurisdiction.
Section 7. My lord, all jurisdiction has been given to the family court.
Can you please bring a copy of the act tomorrow?
Yes, I have it.
You have it. Very. So that is one objection you are taking at the inception.
And jurisdiction of all other courts have been barred by this act.
Family Courts Act.
Family Courts Act. That is one. The other side would be relying upon a judgment passed by your lordship.
So we can distinguish that. If
yes.
That's sitting singly.
Yes.
In any event, that's not binding.
No. Regarding these issues.
Regarding issue may not binding on a division.
No.
In that there is a property aspect involved in respect of the minor's property.
No.
But if that is there, then city courts derive jurisdiction. Because the property aspect can be only tried by the civil court. But with regard to the custody of a minor or a child, that has to be decided by the family court and no other courts.
We'll consider
but they filed it before the civil court. That is what the learned judge also held.
Family Courts Act আনিয়ে রেখে দেবেন দুটো কপি Family Courts Act We need those.
But the child
Actually,
will
North Korean
be-
Guardians and Wards Act, City Civil Courts Act, or Family Courts Act. Yes.
Right of
the
visitation of father.
child has a class 12 examination in the month of
No,
February.
we'll consider that. We have not yet heard it. Definitely, we'll consider that. Due to paucity of time, the matter cannot be heard today. Let the same be placed under the same heading tomorrow. Order what will reach tomorrow.
Great.
ডেকে না উঠে যায় হয়তো জিষ্ণু আসতে পারেনি ওদের ডেকে নিন
Would you lordship kindly, my lord?
প্লিজ 3 মিনিটের কি আপনি শুনবো
Immediately next matter, maybe 35 may be taken up now.
35 maybe
35 will be taken up now. If we can at all take.
now it's we have 2 minutes left
Yes. That's why 36 if the matter is taken up after service. I won't be available. I mentioned before, maybe.
Mr. Mukherjee
My lord, in 36, I was submitting.
yes let him conclude his submission
Yes, yes. Thereafter,
we'll hear you after Saraswati Puja. No difficulty it's a part matter
Yes,
so we are not passing any order right
yeah, no problem.